Yes. They mention. Yes.
Your Lordship, may I be permitted to mention for one application under Guardianship and Works Act?
Yes.
Application of section 5.
My lord, may I be permitted to mention for application?
Yes. Follow.
May it please, Lord.
Yes.
Dependent is the appellant.
আপনি একে ডেকে পাঠান তো টোটোওয়ালাকে ডেকে কি জানা অজানা কে আছে তাকে ডেকে পাঠান একবার এখানে ডেকে পাঠান বলুন আমি ডাকছি Yes, sir.
Dependent is the appellant before your lordship. Suit
There is
for
no caveat in the matter.
no caveat. Suit for declaration and recovery of khas possession. First of all, I like to draw your lordship's kind attention to the plaint at page 10 of the application for injunction.
Yes.
Kindly have you kindly got it?
You got it. Yes.
Yes. Paragraph 3.
Yes.
That the property fully described in para number 2 above is owned by the present plaintiff and the defendant is the monthly tenant therein. That the monthly tenancy is according to English calendar commencing from 25th May 2021 to 24th May 2024. That the monthly rent for the suit premises is 2,500 exclusive of all other charges and taxes. Paragraph 7, that defendant is occupying the suit premises as tenant and thereafter since 25th May 2024, the defendant is occupying the suit premises as forcible possession. Paragraph 9, that the brief facts of the present suit are that on the month of May 2021, defendant came to the plaintiff and requested to take on rent the property in question. Paragraph 10, that it is pertinent to mention that the plaintiff considered the same and allowed him to take on rent the above mentioned property. Then paragraph 12, last 4 lines, that both the defendants along with the property holder came next day to the plaintiff and gave the plaintiff a sum of money which is 5,000 and further gave an assurance to give the total initially money along with the rent for the month. Now, paragraph thereafter at page 12, paragraph 19.
Yes.
That for the reasons stated of the plaintiff wants to terminate the tenancy of the defendant and calling upon him to vacate the suit premises and hand over vacant possession of the same to the plaintiff. So, it is admitted that I was a tenant and I am in possession. That's why, suit for recovery of possession has been sought for. Now, in this suit, an application for injunction has been filed. This is which is almost replica to the plaint. Now, what is the prayer there? If you will kindly turn to page 18.
Yes.
Paragraph 23, that the under this above circumstances, the defendant is
Paka structure and not to transfer, you can understand, but going over is contrary to their plaint.
Yes. Now, the prayer is to allow the ad interim injunction against the defendant, restraining them from going over and to interfere over the land.
That's what we are saying. Going over to the property means if they are dispossessed, you are dispossessed.
Yes.
The rest, not to transfer to third party and Paka construction, we can appreciate.
Yes.
Now, what was granted?
The learned judge, if you kindly see the order of past, the order impugned
says that can be made only with due process of law.
Yes. Now, last but one paragraph from the portion of order, the 4th line, that the civil suit when it goes to a trial takes time to arrive at judicious conclusion till
where is that?
Internal page 2
of the trial court.
Of the trial court's order, where it is ordered, the last portion is ordered before that.
Trial court, you are saying?
Last page of the
yes, got it.
The paragraph starts with that further, if the injunction order is not passed on the defendant, the plaintiff will suffer irreparable loss and injury, as it has been established that the defendant is running the shop premises, earning income by
this
sales.
Is somewhat like the instead of relegating to the criminal court, it has been done by the civil court itself.
Yes.
So what is the appeal court affirmed this?
No, against this order, I have preferred this appeal before your lordship. suit is valued at
One
rupees-
misappeal order is there?
misappeal manner by mistake and misappeal was preferred, then it has been withdrawn.
Valuation is what? What is the valuation? One lakh 50.
1,50,000 and 100 for injunction.
The present suit has been filed. The suit from which the present appeal arises has been filed by the respondent stroke plaintiff for eviction of the defendant stroke appellant. Full stop. Next para. In such suit, comma, an application was filed praying for temporary and ad interim injunction restraining the defendant stroke appellant from going over and or interfering with the suit property of suit property and or raising any type of pakka construction or not to lock and key the suit property till disposal of the application. Full stop. In connect upon hearing the injunction application, comma, the learned trial judge allowed the said application by restraining the defendant stroke appellant from going over and interfering with the suit land of the plaintiff or from alienating the suit property or from changing the nature and character of the same or from putting lock and key on the premises till disposal of the suit. Full stop. The reasoning of the learned trial judge was absurd, comma, to the effect that a civil suit, comma, when it goes to trial, comma, takes time to arrive at a judicious conclusion. Until then, the plaintiff suffers irreparable loss and injury, as he neither gets to enjoy the suit property nor get any income from the suit property. Full stop. Next para. Initially, by mistake, comma, a miscellaneous appeal was filed before the district judge, but subsequently the same was withdrawn and this appeal has been filed against the order of the learned trial judge. Full stop. Next para. The impugned order is ex facie absurd, comma, since by way of injunction, comma, the learned trial judge has granted the entire relief of eviction sought in the suit, comma, more so in the teeth of the specific admission of the plaintiff stroke respondent that the petitioner that the appellant is a premises tenant in respect of the property, comma, without following the rigors of law. Full stop. Thus, comma, thus impugned order is thus, comma, we prima facie find that the impugned order is palpably illegal and dehors all known tenets of law. Full stop. Accordingly, the appeal is admitted and shall be heard on the grounds as taken in the memorandum of appeal and on the questions as formulated above. Full stop. Next para. There shall be stay of operation of the impugned order bearing order number 7 dated July 5, 2025 to the limited extent that the same restrained the appellant stroke petitioner from going over and interfering with the suit land of the plaintiff and from putting lock and key on the premises. Full stop. Next para. However, comma. Yes.
Without I am running a business there. This is my shop room.
You can put your lock and key. You are
Yes, I
staying
can.
that portion.
Yes, yes,
You are staying that portion.
yes.
Lock and key on the suit premises. Full stop. However, comma, it is made clear that the other portion of the impugned order restraining the plaintiff defendant stroke appellant from changing the nature and character of the suit property is not stayed. Full stop. The above order of stay shall continue till the disposal of the present application as well as can 1 of 2025 on the respondent, indicating that the application shall be listed for hearing on September 15, 2025, when an affidavit to that effect shall be filed by the appellant. Full stop. Affidavit in opposition to the application, comma, if any, shall be filed by August 28, 2025. Full stop. Reply, if any, shall be filed by September 9, 2025.
I'm ready.
এটা কি আমাদের কাছে কি হ্যাঁ রেগুলার যেখানে বললাম listed on such and such before the regular bench having determination. Yes. Thank you. এখন দিলেন, হ্যাঁ। চলেন, ঠিক আছে, perfect. আপনি বলেই আপনাকে ডাকলাম এখানে। ঠিক আছে,
My lord, I am appealing for the petition appeal.
And I am for the defend number 2, my lord.
But for the recipient number 1, my lord,
Lord, I appear for defendant number 1. Your lordship will pardon for joining from here, Lord Patna.
no difficulty, no difficulty. Thank you. Yes.
Lord.
My lord, I don't know, my lord, why we are bothering your lordship with this application. This is a very simple application, and I don't know why, my lord, an ad interim order which was passed in my client's favor was vacated, my lord, under Order 39, Rule 4. I give your lordship shortly the background. My lord, 10 electric transformers were to be manufactured by me to be supplied, my lord, to the defendant number 1. Kindly see the defendant number 1 is the North Bihar Power Distribution Company. And my lord, I was engaged by Laser Power, who were the contractor of North Bihar. I was, my lord, given this contract of supplying only the 10 transformers. So these are huge things. My lord, they are to be, my lord, supplied to North Bihar Power Distribution. We supplied, my lord, 8 of them. 7 of them have been tested in terms of the contract. Appropriate, but the certificate has been given that it is there is no problem with this. So, my lord, they have been already installed in the my lord, in Laser Power infra. Now, my lord, insofar as the 8th is concerned, 8th had been tested, passed. But, my lord, North Bihar Power Distribution Company issued a letter whereby, my lord, directed this particular transformer to be taken to Bhopal, their own testing laboratory, for the purpose of testing. And so, my lord, we moved applicant, we filed the suit. Suit, kindly see, my lord, the suit is the plaint your lordship will please to find at page 20. I take your lordship to straight to the prayer portion.
Yes,
And we come to, it's a 3 pages plaint,
yes.
page 23.
Yes.
Your lordship sees decree for declaration that the letter number so and so dated 21st April 2025 written by the defendant number 1 is bad in law, illegal, and should be set aside.
What
And
does the
decree
letter
for-
say, Mr. Mitra?
Well,
What does the letter say?
my lord, kindly come to page 64. This is a short compass. I don't know why we trouble your lordship with these things. Kindly come to page 64. This is from North Bihar Power Distribution Company, issued to the defendant number 1, not to me, regarding coordination with Mr. Neeraj Kumar, Assistant Electrical, for testing of 10 VA power transformer, makes Rajasthan Transformer, this is my client, switchgear of Jaipur. As per direction by MD NPDCL, in the review meeting dated so and so, is directed to conduct a test of 10 MVA power transformer, make Rajasthan Transformer Jaipur at CPL so and so, has been assigned to accompany the transformer during transportation and testing. Hence, you are requested to coordinate with so and so. We are aggrieved by this particular letter for 2 reasons. Well, we have supplied these transformers insured for the purpose of, my lord, transportation up to the site. After testing, it was installed in the site. Then it was directed to be taken.
But this is a premature suit, Mr. Mitra.
I tell you, Lordship, this is exactly what I shall submit to your Lordship.
Yes.
My lord, the petition, appeal, suit can all be disposed of before your Lordship. I tell you, Lordship, how. Kindly, my lord, this is what was passed at page 64. Kindly come to page 63 now.
Yes.
This is, my lord, written by Laser Power, who was the contracting party with North Bihar. See, my lord, what they have written to Rajasthan Transformers and Switchgears to us,
To you, yes.
to me. My lord, in the first paragraph, I'm in the first two sentences, I'm not troubling your lordship. We have received the said letter
They
by
say it's baseless because it was already tested.
my lord.
They say it was this further test was baseless because it has already been tested.
It has already been tested. So, my lord,
Right to
defendant-
you, yes.
defendant number 2 also is aggrieved by this particular direction,
Obviously, yes.
because naturally this from Ghaziabad it is to be transported that
But
huge.
you don't have any business in interfering. They let them test it.
No,
If they say that your contract is terminated or something like
Yes.
that, then you have a cause
No,
of action.
my lord, your lordship is perfectly
You
right.
should have advised them.
This is exactly what I thought. And kindly see the interim order, ad interim order which was passed. This is the order, but this order perhaps should have continued. This order is at page, ad interim order. Kindly, my lord, come to page 65. It's a well-reasoned order, and after, my lord, narrating the facts which I am not troubling your lordship with, kindly come to page 67,
Yes.
the ordering portion. First of all, my lord, Hindustan Petroleum Corporation has been referred to, and which says, paragraph 33 has been quoted, that notice should be served about the middle of paragraph 33. Notice should be served on the dealer sufficiently early so as to give him adequate time and opportunity to arrange for his presence during the test, and there should be admissible evidence for such service of notice on the dealer. Strict adherence to the above requirement is essential in view of the possibility of manipulation in the conduct of the test if it is conducted behind the back of the dealer. Then, my lord, kindly see what the order which was passed. Hence, the prayer for ad interim order of injunction is hereby allowed in terms of the order given below. Accordingly, there shall be an ad interim order of injunction restraining the defendant number 1 from conducting any test of the products in question at CPRI Bhopal in pursuance of its letter dated 21st April 2025, being part of Annexure E at page 22 of the instant temporary injunction application, without giving sufficient prior notice and reasonable opportunity to the plaintiff to be present at the test site. And if such test is conducted before communication of this order to the defendant number 1, in that case, the result of such test shall not be used against and or by binding upon the plaintiff.
This is premature. Mr.
Well,
The suit is not maintained.
Well, I submit to your lordship. Kindly see, my lord, this particular order was passed. This test has not yet been held.
See, your insurance was till the site and destination of defendant number 2.
Yes.
So your liability is over when it reaches the destination of 2.
No, but then again, what I am apprehensive of is this.
That is the basis of this apprehension that
Well,
is being called up.
I should be given notice. I should be allowed to be there. That's all that I'm asking for.
Mr.
I'm saying, my lord,
If any penal action was taken against you or anything of that sort,
no, then I shall file a fresh suit.
yes, but at this stage you don't have a right of notice even.
No,
Why?
but this order had been vacated.
Mr. Mitra, I buy something from you,
Yes.
right, through somebody else.
Yes.
So I have a right to have my own tests and whatever for my purpose.
Why should I not be present?
Why should you be present?
Because
what
I
is
am
your
the
locus
manufacturer.
standi?
My lord, kindly see.
Your liability ends till the site of the defendant number 2. You are not bothered after that what happens.
No,
Whatever happens, defendant number 2, if the defendant number 2 sues you later on, or the defendant number 1 sues you, then you will have a cause of action.
Well,
At this stage, nothing.
My cause of action is very simple. That without notice to me, my machine is being tested by you.
They can do whatever. They have purchased the machine. They can do whatever with that. They may have it tested, Mr. Mitra. We know it's conjecture and sermon. They may have it tested for some particular purpose, whether that will be suitable for that.
No, but very well, my lord. If
But
that
this is there is no cause of action disclosed in the plaint.
But
Shouldn't the plaint be rejected?
well, I was waiting before lordship.
If you are the judge, you would reject the plaint.
My lord, had I been the judge, I would have said that give him notice, ask him to be present when the inspection. My goods are being.
You have no right to notice.
Well, I don't have any right to be present. Well, kindly come to paragraph. Kindly come
no
to page.
penal action has even been contemplated against you.
No, if any penal action is taken, of course, I shall come before the court. Another suit will have to be filed. This suit is very restricted. That's why, my lord, drew your lordship's attention to the.
Your paragraph 14 is the only cause of action, Mr. Mitra.
Yes.
Paragraph 14 says from the letter dated such and such it transpires, the defendant number 1 will be sending the materials to Bhopal, and in case of such transit, if any damage is caused by to the products, then in such event the plaintiff cannot be held liable and responsible for the loss and damage.
Yes.
So you have stated what you had to say, but they have not even fixed any liability or
No.
said that it is.
No, of course not.
They can send their own. It's their machine now.
Well,
They
they
can do whatever they.
well, they are going to take give inspection, take inspection this morning. There today, this afternoon.
Let them do
I'm
it,
not-
Mr. Mitra. We don't
Let
mind.
them do it. I am not. I'm saying, well, let restore this interim order. That
This is,
give me notice.
this suit is like what Mr. Mitra will tell you. Sometimes political parties cannot give certain sops to their citizens. So what they do, they move court. They know they won't get any relief. Then they say the court has done it. This is precisely that.
No,
You have
but
moved court.
I-
This is
only-
a preemptive suit.
Only thing is this one. If I am given the opportunity of being present there,
Mr.
I
Mitra,
shall
why
go
should
over
you?
there.
Why should you? You can take this point if a claim is made against you regarding damages or that you suffer.
That is of
Your
course.
insurance is up to the site of defendant number 2. Your job is over after that. They cannot even sue you from there on.
Kindly make that clear. Kindly make that clear. Otherwise, I am being tied down to this. I am supplied. These are very valuable materials.
We'll say that your apprehension is premature and baseless at this stage.
Well, apprehension is premature in the sense you
They can test their own machines. They can do whatever. They can drop it from the Tower of Pisa and have it broken off even.
so
But
long as
they cannot hold you liable. If they hold you liable, if they send one letter to you saying that you are guilty of negligence, your defense will be, you have disclosed your defense in this suit.
Well,
My liability was still the site.
very well. Kindly see paragraph 33, which has been quoted from 2010 three Supreme Court cases at page 67. Can just kindly look into that. This is the only thing I am saying. This is cited by us, before the learned trial judge.
Yes.
The guideline followed by the corporation require that the dealer should be given prior notice regarding the test so that he or his representative also can be present when the test is conducted. The said requirement is in accordance with the principles of natural justice and the need for fairness in the matter of terminating the dealership agreement, and it cannot be made an empty formality. Notice should be served on the dealer sufficiently early so as to give him adequate time and opportunity to arrange.
Mr. Mitra,
for
that
his-
must have been a case where damages were claimed. Must have been a case. We have not seen into the facts.
Well, of
But
course,
if you have a copy of the judgment,
yes,
we'll
I've got a
definitely,
copy. I brought that.
we are, without even looking into that, it must have been a case where damages were claimed.
Well, of course, your lordship is right, perhaps, because kindly see the second sentence. The said requirement is in accordance with the principle of natural justice and the need of fairness in the matter terminating the dealership agreement. This question of termination.
Let them terminate, then come. The suit is not maintainable. If it was Justice Banerjee's court, then your patent would be rejected. My mentor, Justice Sanjeev Banerjee.
Yeah. Then, perhaps I wouldn't have
No,
been.
no question of interest.
Well, then, perhaps.
Yes, you can have a case, point in saying that 39(4) is not the proper remedy, but this is undue hardship on them.
Yes, I thought that there is no dispute between the parties, really. Only the inspection thing is the only thing. And I would have been satisfied if the inspection I would have been allowed to be present. That's all that I wanted. And that's exactly what has been granted.
We can make one subject to, you have not yet heard them. We can make an observation that we'll say that this your apprehension at this stage is baseless and premature. These two expressions we'll use. But still,
kindly do not make
no basis. What is the basis? Nothing has been written to you regarding claim of damages.
No, I'm not
Show us something to show that damages will be claimed or liability will be fixed on you. Baseless in the sense that there is no basis. Achha, very well, we'll say without any basis.
Kindly see time and
We'll use
action
the expression without any basis because you are appearing in deference to your appearance. We'll say instead of baseless, without any basis.
No, not in deference to my
Definitely, Mr. Mitra, your appearance means something to us also. But and to them also, because we'll just talk, because we'll say this apprehension is without any basis at this stage and premature. And in any event, we can add one line. In any event, the defenses you have taken here, that your liability is still, the insurance is still the site and destination of defendant number 2, is in any event available to you if they make any claim against you.
Very well, your lordship, as your lordship.
That will say that will serve your purpose. Yes.
So far, I am concerned, my lord.
Yes.
I am to inform my lord, that the very beginning I have said that there is no privity of contract between defendant number 1 and the so-called plaintiff.
Oh, you are for
It is
defendant
all
number 2. You are for 2.
For defendant number, it is only between defendant number 1 and 2 are in the contracting party. All
Yes.
supply have been made by defendant number 2.
Right,
And-
right. We also think so. We agree. We agree with that.
And so, my lord, we gave notice in terms of the contract to the defendant number 2
Right.
that one of the transfer, what happened, my lord, 123 transformers we have ordered.
Right.
Only 10 was to be supplied by my lord Rajasthan, Jaipur. That is all Jaipur, my lord. Nothing has happened at Calcutta. And it is RTGS Corporation. Now they have first time enclosed an authority. Suit itself was not maintainable. How a unit? And if your lordship see last page of the memo, first time I find that authorization to sue given to RTGS Corporation. And it is an unit they say they have got at Havara. But the fact is that we had given my lord approval for purchase to defendant number 2 to purchase from Jaipur, and they all purchases out of 10 my lord, 8 only were supplied. Defendant number 2
Mr.
has
Singh
now
will not go into the merits so much at this stage because
But
obvious
my
for
lord,
obvious
your
reasons.
lordship is
Only one
100%
thing.
right.
Only
I
Mr.
am
Singh,
not going
Mr.
to
Singh, we are
sue.
sorry. Only one thing. One question to you. You have given a notice on defendant number 2,
Two,
right?
two only.
2 only.
Yeah.
So
To appear because in terms of contract we have to all
right,
costs
right.
have to
So
be borne by us.
defendant number 2 can be present at the inspection.
Yes, and what really happened, both are
Ask them to take your
selling in the
manners.
same boat. And now, for
Ask
my
them to take your
lordship
manners.
information, that today,
Yeah,
yesterday,
we
we
will
have
not advise you.
received all at our own cost. Your lordship is agreed transformer to be placed at the
No, we'll
marketplace.
dismiss the appeal, Mr. Singh, on the grounds as we indicated.
So-called plaintiff is not. There is no privity of contract. I have no right to sue even. That to that extent I say below. Section 230 of the Contract Act,
Yes.
your lordship say, where there is a principal is present, agent can't be sue. He is an agent of the defendant number 2.
Yes, yes. Defendant number
He
2
has-
may sue defendant number 1 if they are hauled up by you.
That is between us, and there is arbitration
Yes.
agreement between the parties.
Right. Very well.
This is not correct at all.
No, we'll not go into that much.
The letters are all letters from them to defend number 1 and defend number 2 all contain my name as the manufacturer. Your lordship kindly come to page 28.
No, it is a
Just
Jaipur
one
unit.
sample. Each letter contains my name. They are
That is
writing.
the Jaipur unit only belong that they have not got at Calcutta any manufacturing unit. Yeah. And the RTGS Corporation, your lordship, pardon me, only a legal person, living person defined in section 5 of the Transfer of Property Act. A company, association or person, individual can sue. RTGS Corporation is not suing us. Company has not come. Unit of a company. And if your lordship see
What
last
sort
page
of
of
ground
the
defense
memo,
is taking?
what they have done now, validating authorization to in state bank of Travancore
This is
case.
totally material because my
Says,
name has been
without
there.
authorization, this suit was filed. See, your lordship, who had been authorized to file suit?
They are acknowledging
RTGS
that I
Corporation.
have
No, Mr. Mitru, what about this? A unit has come up. Unit is not a.
Unit, no company has not come.
they are
There
the Rajasthan
is no relationship with that.
transformer and switchgear
First time
Jaipur.
we said
They are the purchase. Your lordship sees the purchase order, then it will be
from
clear.
Jaipur.
Well,
all-
kindly come to page 25.
Everything happened
What
at
my
Jaipur.
learned friend is saying, I don't know. I don't understand this.
You have
Rajasthan
not
transformers and
understood.
switch gears.
Yes.
Right.
That is the plaintiff.
Right.
Plaintiff.
Mr. Singh, we won't record your arguments because we are dismissing the appeal at the order 41 stage.
Yes, my lord, that is your lordship. Take it from me. I have no right even to sue to my learned friend.
Understood.
Any
Understood.
dispute that is
Understood.
between myself and the defendant number 2.
The present appeal has been preferred by the plaintiff in a declaratory suit. To the next para, the plaintiff supplied, plaintiff is the manufacturer of a certain number of electrical transformers. Full stop. Full stop. Such transformers were supplied to the defendant stroke respondent number 2 pursuant to a contract entered between the defendant stroke respondent number 2 and the defendant stroke respondent number 1. Full stop. Next para. It is pleaded in the plaint that the that it was specifically stated in the work order issued to the plaintiff stroke appellant that the materials would be insured by the plaintiff till the site and destination of defendant number 2 stroke respondent number 2. Push up next para. Subsequently, by a letter dated April 21, 2025, issued by the defendant number 2 to the defendant number 1, comma, it was indicated that the one transformer was to be tested, Mr. Mitra.
No, there are my lord, 10
It is now
transformers.
being tested, my lord.
Eight of
One
them my lord,
trans-
have been
All of
supplied.
those would be.
Yes, 7 have been already installed. They were quite satisfied with the test.
That one
Only
of
one had been
that one of the transformers manufactured and supplied by the plaintiff stroke appellant would be sent for further testing to Bhopal. Full stop next para. Learned senior counsel appearing for the appellant submits that by the impugned order, comma, an initial order of ad interim injunction granted by the learned trial judge was vacated. Full stop. However, comma, it is pointed out by learned senior counsel, comma, by placing reliance on the judgment of Hindustan Petroleum Corporation Limited versus Super Highway Services reported at 2010 3 SCC 321 that the guidelines to be followed by the said corporation require that the dealer should be given prior notice regarding the test so that he or his representative also can be present when the test is conducted. So it was further laid down that notice should be served on the dealer sufficiently early so as to give him adequate time and opportunity to arrange for his presence during the test, and there should be admissible evidence for such service of notice on the dealer. Full stop. Strict adherence to the above requirement, comma, it was held by the Supreme Court, comma, is essential in view of the possibility of manipulation in the conduct of the test, comma, if it is conducted behind the back of the dealer. Full stop. Next para. The learned trial judge, comma, by an order dated April 25, 2025, granted ad interim injunction on the premise of such ratio to the effect that the defendant number 1 shall be restrained from conducting any test of the products in question at CPRI, comma, Bhopal in pursuance of its letter dated April 21, 2025, without giving sufficient prior notice and reasonable opportunity to the plaintiff to be present at the test site, and if such test is conducted before communication of this order to the defendant number 1, comma, in that case the result of such test shall not be used against and stroke or be binding upon the plaintiff. Full stop. Next para. Such order was subsequently vacated by the order impugned in the present appeal
4th August 2025.
on August 4, 2025. Full stop. Next para. The learned trial judge, comma, while doing so, comma, inter alia observed that the defendant number 1 being well within its rights to get the supplied electrical transformers tested by a reputed accredited laboratory at CPRI Bhopal cannot be kept on hold by the court, and consequently the court found that the plaintiff admittedly does not have prima facie case and balance of convenience in its favor, and no irreparable injury would be caused to it if the defendant number 1 is permitted to get tested the goods supplied to you it by the defendant number 2
below.
to defendant number 2 at CPRI Bhopal. Full stop. Next para. On such grounds, comma, the interim order of injunction was vacated. Full stop. Next para. Upon hearing learned senior counsel, comma, we find that there is no basis of the apprehension of the plaintiff stroke appellant disclosed in the plaint as to the plaintiff being subjected to any penal action if the results of the tests to be conducted indicate that there is some deficiency in the electrical equipment transformer. Full stop. Next para. From the four corners of the plaint, comma, we do not find any present cause of action or basis of apprehension in that regard by the plaintiff stroke appellant, comma, more so, comma, since it has been pleaded in paragraph number 14 of the plaint that the work order itself specified that the materials would be insured by the plaintiff only till the site and destination of defendant number 2. Full stop. Thus, comma, any penal action, comma, if taken, comma, would be between the defendant number 1 and the defendant number 2 as per the averments in the plaint and the injunction application. Full stop. Next para. In any event, comma, if any action is sought to be taken against the plaintiff on the ground of supply of faulty material, comma, the defenses as disclosed in the plaint, comma, to the effect that the limited liability of the plaintiff extended up to insurance to the site and destination of the defendant number 2, and that prior tests were already held at the time of supply of such electrical equipment. Full stop. Next para. Hence, comma, we do not find any current basis for grant of injunction in favor of the plaintiff stroke appellant. Full stop. It is trite law that for a future or prospective cause of action, comma, the rudiments of which is not rooted RWTD. In the present, comma, injunction cannot be granted by courts. Full stop. Next para. Thus, comma, we are of the opinion that in addition to the grounds given by the learned trial judge while passing the impugned order, comma, the defendant number 1 would be subjected to undue hardship if the ad interim order was permitted to continue, comma, since it is well within the domain and prerogative of the defendant number 1 to have the equipment purchased by it tested by its own chosen technicians. Full stop. Next para. In such view of the matter, comma, we do not find any illegality or infirmity in the impugned order. Accordingly, FMAT 335 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure in the light of the observations made above. Full stop. Consequentially, can 1 of 2025 as well as can 2 of 2025 are disposed of. Full stop. It is made clear that the above findings are all tentative in nature, comma, only for the purpose of considering the present appeal from an order passed under Order 39 Rule 4 of the Code of Civil Procedure, and shall not, comma, in any manner, comma, adversely prejudice either of the parties or influence the court in any manner at any subsequent stage of this suit. No address to cost. প্রথমে affidavit satisfied today.
Probably.
My learned junior Malad says something. I think I should communicate. Well, instead of dismissing, can your lordship not say dispose of? But I leave it to your lordship.
You cannot dispose of under Order 41 Rule 11.
What do you appear for the appeal? My lord, there is a delay. My lord, there is a, my lord, ex parte decree of in a suit for specific performance of contract, which is being faced by the legal heirs of the original defendant.
This is not a matrimonial suit. We don't.
No,
have
this
to
is, my lord, this is from my lord Justice Shobhit.
Then.
No, my lord,
What is the urgency? Section 5, what can be the urgency?
my lord, kindly, my lord, because I am facing a via the legal, if your lordship enters into the merits.
Section 5, how can we?
My lord, there is an
copy of the-
execution case fixed on 19th. My lord, we are the legal heirs of the
We can
original
at least
defendant.
direct you to serve copies of the both the applications and the memo on the other side.
My lord, kindly protects me for 19th, my lord.
No.
Because my lord, my
What
lord,
is the
we-
delay? What is the delay?
my lord, delay is my lord 813 days. Because my lord, the original defendant, my lord, he received the summons of the suit.
No, Mr. Das.
Now, my lord, what had happened thereafter, my lord,
We'll
he,
direct you to serve
my lord, he
copy.
was
Will,
a septuagenarian. He suffered a, my lord, a fracture.
whatever
in
may be
his,
the case,
my lord,
800 something days delay without hearing the other side. We cannot verbally
But
control.
at least, my lord, a liberty to pray for adjournment on, my lord, Monday.
If this
on
was a
Tuesday.
suit in any event, Section 5 does not. If this is something else where Order 41 Rule 11 hearing is not necessary, we could have. This is first appeal.
First appeal.
But even then,
But my lord,
800
a
days
liberty
delay-
to pray for an adjournment on 19th, my lord,
No.
because my lord, we are facing, my lord, the draft copy
No, you
of
can
the,
only cite that you have directed copies to be served.
my lord, kindly gives me some protection, my lord. That is why, my lord, I am present before your lordship.
No.
Because my
Learned-
lord, these are the widows and two daughters of the original defendant
What
who
is
has
the decree
died.
passed?
Well, a decree passed is, my lord, directing us to execute the deed. The draft copy of the deed has also been sent to us.
You are not
have received
ousted
it
from
on-
your home or something like that.
No, my lord, that's a residential house.
Yes, but if the deed is directed to be done, that will take some time.
No, my lord, the execution.
Specific performance
performance of
degree.
a contract.
It will take some time, even if it is directed. If a deed is even executed, I mean, if the appeal is allowed, then you are not dispossessed by this. So this widow and two daughters formula does not apply here.
My lord,
If you had to be dispossessed, Mr. Das, we definitely think otherwise.
but on the, my lord, prior to
You would not
filing
be
of the
dispossessed,
suit,
you-
my lord, this person was completely in bed.
800 days delay, you does not lie in your mouth. No.
No, my lord, first, my lord, he has expired now on 1st of October 24.
We have full
We
sympathy.
come to
We
know
have
about
full
the suit
sympathy.
after the execution case
No.
summons are received. by us.
800, over 800 days delay, no question of that.
But our knowledge is, my lord, from 11th of June.
Learned counsel for the appellant pleads extreme urgency in the matter, inasmuch as if the decree of specific performance is executed in the meantime, the appellants, who are the widow and the two daughters of the deceased original defendant,
Lordship.
would suffer serious prejudice and irreparable injury. However, we find that the application is accompanied by an application for condonation of delay of a period of more than 800 days. That apart, even if the decree is executed in the meantime by directing a deed to be drawn up and executed, the same would not translate automatically into the appellants being ousted of the suit property or suffering so irreparably that despite the huge delay in preferring the appeal, we would grant stay even during pendency of the application for condonation of delay. Hence, we can at best direct the appellants to serve copies of the applications on the respondent, but not pass any interim order at this stage, particularly in view of the immense delay in preferring the appeal for whatever reasons. Accordingly, the appellants are directed to serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondent,
But there is a, my lord, sole opposite party.
respondent, indicating that the matters shall be listed within a week before the appropriate bench having determination. Liberty is given to the appellants to mention the matter for being listed before the appropriate bench on the ground of urgency. The appellant shall file affidavit of service on the returnable date before the appropriate bench. Not being determined. Before the bench having regular determination.
Great.
Yes.
My lord, I'm appearing for the appellant, my lord.
Yes.
At the earlier occasion, there was a direction upon me to serve upon the,
You have served a notice?
yes, my lord, but
Yes. You are appearing?
আমি রেসপন্ডেন্ট স্যার
আপনি নিজে রেসপন্ডেন্ট?
হ্যাঁ।
আমরা এটা ডিভোর্স সুট থেকে অ্যারাইজ করছি, রেস্টিটিউশন অফ কনজুগাল রাইটস।
No, my lord. There was a matrimonial suit praying for divorce.
Right.
The husband had, I'm appearing for the husband appellant. The
Then
suit,
it was converted to divorce suit.
no, my lord. Restitution was initially filed. Thereafter, at the stage of reconciliation,
Oh yes, remember.
yes,
Your divorce suit, her restitution.
later
আপনি
non-prosecution.
বাংলায় বলবেন না ইংলিশে বলবেন?
হ্যাঁ স্যার একটু বাংলায় বলবো
হ্যাঁ 100 বার বলুন।
স্যার
না আমরা এটা না আজকে শুনছি না ফাইনালি, আমি আপনাকে বলছি, আপনাকে বলছি এইটা আমরা কয়েকটা ম্যাটারকে ইয়ারমার্ক করেছি যেগুলোতে মিডিয়েশনের জন্য চেষ্টা করা যেতে পারে। এই কারণেই করেছি, এখানে ওনার ডিভোর্স সুটটাও ডিসমিস হয়ে গেছে, কাজে উনি আপনার বিরুদ্ধে ডিভোর্সও পাননি, আর আপনার যে ফিরে যাওয়ার রেস্টিটিউশন সুটটা ওটাও ডিসমিস হয়ে গেছে, মানে আপনি ফিরে যেতেও পারবেন না, মানে মাঝামাঝি একটা জায়গা। এইটা মিডিয়েশনে আমরা পাঠাচ্ছি এই কারণে যে ট্রেন্ড মিডিয়েটর আছেন যারা দুজনের সঙ্গে আপনাদের টেবিলে বসিয়ে কথা বলে আপনাদের যদি না এগ্রি করেন তাহলে মিডিয়েশন হয় না। মিডিয়েশন করার ফলে হয় আপনারা আলাদা থাকা ডিসাইড করবেন, নয় আপনারা একসঙ্গে থাকা ডিসাইড করবেন। এই চান্সটা আমরা নিচ্ছি, আমরা এটা মিডিয়েশনে পাঠাবার জন্য আজকে লিস্টে দিয়েছি। মিডিয়েটরের কাছে গিয়ে যদি মিডিয়েশন ফেল করে, আপনারা না এগ্রি করতে পারেন, তখন আবার কোর্টে ফিরে আসবে, আমরা মামলা মেরিটে শুনে দেবো। ঠিক আছে, শুধু এই পারপাসে আজকে এসেছি মিডিয়েশনে পাঠানোর জন্য। আমরা এটাই রেকর্ড করছি, এটা যেহেতু সুটের নেচারটা এরকম, আমরা মনে করছি এটা ফিট কেস ফর মিডিয়েশন, আমরা মিডিয়েশনে পাঠাচ্ছি বলে মিডিয়েশনের কাছে যাবে। এইটুকুনির জন্য আজকে লিস্ট এসছে, ঠিক আছে? The respondent appears in person with the leave of court, full stop. The appellant is represented through counsel, full stop. Upon hearing learned counsel for the appellant and the respondent in person, comma, we find that the appeal arises out of a judgment whereby the husband's divorce suit was dismissed, while at the same time the suit filed by the respondent wife for restitution of conjugal rights was also dismissed, comma, thereby creating an impasse between the parties. Full stop, next para. As such, comma, we feel that the matter has a fair chance of being resolved by mediation by trained mediators. Full stop. Accordingly, the file be sent to the Calcutta High Court mediation committee for the purpose of resolution of the dispute by way of mediation. Mediation আমরা পাঠালাম, ওরা আপনাদের নোটিশ দিয়ে, please keep her posted if you come to know when is the date, because she's appearing in person.
My lord, only one thing, no separate suit for restitution was filed. It was a counter claim.
আচ্ছা,
There was a written statement, much later state it a counter.
যেখানে বললাম না, and the suit of the wife, respondent wife for restitution of conjugal rights, wife এরটা ওইটা কাউন্টার ক্লেম করি, কাউন্টার ক্লেম অফ দি ওয়াইফ এরটা কাউন্টার ক্লেম, হাজবেন্ড এরটা সুট, ঠিক আছে?
স্যার একটু কথা বলবো?
হ্যাঁ,
স্যার আমার ডিভোর্স কেস যখন চলছিল তখন আমার 15,000 টাকা করে লট ছিল, কেস বন্ধ হয়ে যাওয়ার
একটা
পর
কথা বলবো,
স্যার
এইগুলো না আপনার মিডিয়েটরের কাছে বলুন, আমরা শুধু এই পারপাসের জন্য আজকে দিয়েছি, যখন ফাইনালি শুনানি হবে যদি মিডিয়েটরের কাছে আপনারা ফুল বলার সুযোগ পাবেন, কোর্টের চেয়ে অনেক বেশি পাবেন, ঠিক আছে? ট্রেন মিডিয়েটর থাকবেন, ওদের কাছে পুরো প্রবলেমটাই বলবেন আপনি, এবং যদি ওতে মিডিয়েশনে না মেটে তখন কোর্টে যদি মামলা আছে তখন ডেফিনেটলি শুনবো আপনাকে, ঠিক আছে? এখন ডিসাইড করছি না আমরা কিছু, শুধু মিডিয়েশনে পাঠালাম আজকে।
অ্যাকচুয়ালি স্যার আমার পয়সা নেই বলে না আমি খুব চাপে পড়ি, আমি 5,000 টাকা করে
না,
পাই।
আপনি নিজে মিডিয়েটরের কাছে, ওটাই তো সুবিধে, আপনি নিজে যেতে পারবেন, আপনার যদি মনে করেন যে কোনো লিগাল এডের দরকার, তাহলে আপনার লিগাল এড অথরিটিকে বলতে পারি আপনাকে ইয়ে দিতে,
স্যার আমি
অ্যাডভোকেট
এই
দিতে।
পার্সনই লড়ছি, কারণ আমার পয়সা নেই যে আমি হাইকোর্টের মতন জায়গায়।
পয়সা ছাড়া লিগাল এড থেকে আপনাকে অ্যাডভোকেট অ্যাপয়েন্ট করা হয় উইদাউট।
কিন্তু স্যার 5,000 টাকা আমি করতে পারছি না স্যার, একটু দেখুন না স্যার কিছু যদি হয়, কারণ
আপনি মিডিয়েশনের কাছে,
বন্ধ করে দিয়েছে, আমি টাকা পাচ্ছি।
আপনারা মিডিয়েটরের কাছে এটাও বলতে পারবেন। নেক্সট ম্যাটার। None appears for the parties at the time of call. Full stop. Next para.
In this matter, I
Yes,
informed Mr. Chandodoy Roy. So he informed me that someone, Mr. Joyjit Rai Chaudhary and Shubhajit Bose is appearing on.
We are not concerned with it. None appears for the parties at the time of Mr. Sarkar. We are not recording your presence. Last occasion we recorded because you intimated that you have given a no objection. But thank you for being present, taking the trouble. None appears for the parties at the time of call. Full stop. This is a matrimonial dispute.
Yes, ma'am.
Since the dispute arises out of a matrimonial proceeding, comma, we are of the opinion that the matter may be resolved by mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of resolution of the dispute between the parties by way of mediation. Next.
Lordship, actually, learned advocate Abdul.
Who is the learned advocate?
Abdul Salams. Abdul Salams. And
You are his chamber junior?
yes, sir.
How long are you practicing?
3 months.
3 months. Start the matter.
And he.
What is the matter about? Tell us that.
Actually, I am not.
Take our file and say what is the matter about. You are passing it over. We'll take up after 10 minutes. After 10 minutes, you have to start the matter, even if Mr. Salam comes. Pass over. Next.
Similar is that status quo. My lord was pleased, my lord, to clarify if your lordship recalls the order passed. Your lordship will see and immediately come back to your lordship.
ওনারটা দিন, ওনার ফাইলটা। Yes, restored.
Order of status quo passed, subsequently restored because of restoration of the appeal. Now now a municipality says that it is Shorkari Jomi and has put up a signage.
They were to take instructions.
Mr. Supratim Dhar appeared yesterday, said that he will be taking instructions.
Yes.
My
I have
lord,
put up a
I have rang to Mr. Dhar to come early. He is saying, my lord, I am going. My lord, the instruction have come to my hand.
what is the
My lord,
instruction?
my lord,
Mr.
instruction is
No, no, what is the instruction? Why have
My
you
lord,
put up that sign?
My lord. Actually, my lord, the signboard so far, my lord, planted or affixed in the said land, that is given by the my lord Panchayat authority, not by us. And Panchayat authority is not party in the instant case. And the instruction is that, my lord, we have not encroached anything, we have not done anything. That is the my lord, that has been done by the my lord.
We'll run
Panchayat
to
authority.
police help. You can take police help
Yes,
to remove it. You will remove it. Learned Counsel for the state files a written instruction indicating that the state has not put up any signboard on the property in question. Full stop. It is indicated that the said sign might have been put on installed on the suit property by the local panchayat. Full stop. Be that as it may, comma, since a status quo order was subsisting at the relevant point of time when the signboard was put up, comma, the appellant will be at liberty to appellants will be at liberty to remove the signboard from the suit property, comma, if necessary with police help. Full stop. If the local police station is approached by the appellants for such purpose, comma, adequate police assistance shall be given by the police at the cost of the appellants for removal of such signage from the suit property. Full stop. What about the appeal? The appeal is otherwise ready.
My lord, is absolutely ready. It's a
Not appeal.
WPLR,
It's a
it's a WPLRT. My lord, absolutely very short point involved. I am a person transacting in land.
no affidavits have been exchanged.
Yes, yes, everything is ready. Paper book is there. My lord, kindly hear it any day.
Let-
Any day.
Can 4 of 2024 is can 4 of 2025 is accordingly disposed of in the light of the above observations. WPLRT 79 of 2017 be listed for hearing under the appropriate heading on August 18, 2025.
Obliged, Your Lordship. My lord,
The instructions filed today be kept on record.
my lord, apart from signage, I am told that some bamboo poles have also signage and
It
bamboo.
is on the bamboo poles.
Signage is on the bamboo poles inside. There are certain bamboo poles on the periphery also. I've given Your Lordship, my lord, certain bamboo.
Whatever is there, you
what-
remove. They
yes.
have not installed anything.
Yes,
So
my lord, signage and bamboo structures. Otherwise, they'll say, Honorable Court has only said remove the signage, keep the bamboo structure.
যেখানে সাইনেজ বলেছি যেখানে যেখানে সাইনেজ বলেছি সাইন
Signage and-
বোর্ড বলেছি না কি বলেছি along with bamboo structures.
Obliged, Your Lordship.
My lord, instead of 18th August, my lord, can it be on
Tell us a date, give us a date. 25th, next
25th?
আচ্ছা 18th না করে রিটার্নেবল ডেটটা 25th করে দিন August 25th.
Would be slightly high on board in that pile.
No. Resounding thumping no. Next. 8. ও পড়ছে পড়াশোনা করছে।
My lord,
পড়ছে
yes, my lord, it was. My lord, it was served.
Yes.
Oh, yeah, he is represented. My lord, very short,
I am opposing this, my lord.
How can it be short then if
very short one
Mr.
because.
Beres appearing cannot be short?
My
There
lord,
must be something
I
in
think,
this.
my lord, I think, my lord, kindly come to page 13 of the stay application.
No, this is in connection to review application.
Review application of the my lord's order.
Which order?
My lord,
Of which order?
that is dated, my lord, were dismissed. My lord, that is dated.
Memo of appeal annex করা আছে তো?
What is the memo?
My lord, 22nd April 2025.
FA file না memo review এর মেমোটা কোথায়?
Thank you. My lord,
No, first we have to see whether the review lies.
yes, my lord, but before that, my lord, yes, I am explaining. I am bound to follow, my lord, they explained before, my lord. My lord, here, my lord,
You are seeking a review of April 22nd order.
yes.
What was directed?
My lord, dismissal of my application for appropriate orders. Saying, holding that there are laches negligence on the part of the state authorities.
What is the scope of review?
My lord, I am.
You are dismissing the review
Yes.
application.
My lord, I am subject to minus again at the cost of subject to minus.
Yes.
Kindly come to page 13 of the stay application. My lord, I think, my lord, I will rely upon the
The Honorable Division Bench presided over then Honorable Justice Mr. Bhaskar Bhattacharya.
That is
Where
not
two
binding on
lawyers-
us otherwise.
Two lawyers, well, I am saying, but before
Not
that,
binding by virtue of relationship.
no, not binding, because on the basis of that, another Honorable Division Bench, I got the order. So up to Supreme Court failed in the review, contempt dismiss,
automatic.
review allowed. Well, kindly see, case 13. There are 15 days delay. Well, according to, my lord, the section 5. It was allowed subject to condition that 5,000.
That was done in that particular case. No straitjacket the proposition of law has been laid down. Every section 5 has to be allowed.
No, my lord, I am coming. Why? Why, my lord, that dismissal actually was made?
delay করেছে,
My lord, kindly consider one thing, my lord.
Yes.
What
What is the error apparent on the face?
Well,
This is
yes,
legal
error.
arguments.
Because, my lord, kindly consider, or there are sufficient reasons. My lord,
This is a legal argument, Mr.
kindly
Attorney.
consider one thing. My lord, let me just give me 5 minutes time.
All right.
My lord, kindly. There are absolutely delay was condoned for 115 days. My lord, there are crores of rupees are being involved. So for state is concerned. My lord, delay condoned subject to payment of 5,000 each to the, my lord, in the favor of legal High Court Legal Services Committee within 1 year. My lord, that was prepared, but my lord, there are some days delays, or 7 or 8 days delays. My lord, that was not pointed out in earlier application. That check was kindly come to page 17 or 16 or not.
This order was passed in this matter only,
No, in all matters.
including this matter.
One, yes, because analogous matters, my lord, in 19.
Right. We are not bothered with the other matters. In this appeal itself, this order was passed. This was the first order.
Are all 16 matters.
Oh, acha, the others are also.
Same. My lord, kindly consider page 16. This was not, my lord, page 16.
Yes.
That our bona fide intention, not that we didn't prepare, but it was not pointed out at that point, or it has not been annexed to that application for appropriate orders. My lord, kindly see 23rd May 2022, the next page, my lord, the checks have already been prepared. My lord, up to 24. Now, my lord, kindly come to 28. Another check. Well, this was not even pointed out in the, not written in that, but in the environment of the appropriate application. This is, my lord, what
you prepared the check within a few days.
No, after the lapse of a few days, that check first thrice once check was issued. That was not pointed out. Twice the check was issued. That was
no. You write on May 23, 2022 itself.
Yes, that is the first
and the
one.
Acha, the other.
Another check was prepared that from 28 onwards.
So what was the last date on which that last check was prepared?
Last check, my lord, 28, my lord, 9 December 2024. 2024. My lord, kindly consider the application which was.
Why didn't you deposit those if those were prepared?
Well, because because the concerned official of the authority intended to deposit the check.
Why didn't he?
Yes, my lord, intended, but my lord, the my lord knows that unless
I don't know.
Order be extended, he cannot take that.
Why didn't you apply for extension?
That's why, my lord, the application for the appropriate orders was there. And my lord was, because it was not pointed out even that so many, well, I am to show my bona fideness. Even, yes, some delay. But my lord, kindly, section 5 allowed only for 115 days. And my lord, the burden, the duty cast upon me to deposit, prepare the check and deposit. I couldn't do this. My lord knows that.
For 3 years.
Yes, my lord, I prepared long back.
But you did
This
not
was
deposit.
not pointed out. Even after that, even 80,000.
This is not a ground for review.
Well, this is.
But Mr. Sen will definitely grant you liberty to take action against the officials who are responsible and recover this amount from their salary. We'll put that in our order and ensure that is implemented.
Kindly consider. State is an impersonal.
That is precisely what we said.
Yes,
state will give liberty to the state to take action, penal action against the officers who are responsible, and they recover
that-
this amount
that-
from their salary.
I will do that, but at the same time, kindly, and otherwise,
not a scope of
otherwise, state interest, kindly protect the state, crores of rupees.
State is not all powerful. State cannot do whatever it likes. The mighty state is not all powerful.
But kindly see, I am what I am on. To show my bona fide, again 80,000 checks have been prepared.
Where is the bona fides in
And-
this? Within
and-
3 years, it was not deposited. And this was directed to be paid to the legal services authorities.
Kindly, it is up to the learned advocate. If the learned
Take action against the learned advocate?
no, that cannot be done.
Why can't be?
Not that.
Why can't
I am not the. I am the last person. to do that.
You are blaming the learned advocate and you are
No,
shying
I am
away.
not blaming
You are
because
saying for the learned advocate.
I am not blaming. I am making humble submission. For that, kindly do not penalize the state. Kindly consider 80,000 plus 80,000 checks are also prepared. Might be. Kindly see. Kindly see page 53. Even I am prepared.
And just imagine the cruelty of it. It
It's
was
not-
directed to the
kindly con-
Mr. Let us complete.
Yes,
It was directed to be paid to the High Court Legal Services Committee within a week to be used
yes.
for the welfare of the children in the correctional homes. And you took 3 years to deposit it.
Pay
Definitely
interest.
not.
I will pay interest. I have stated. 80,000 I have prepared. Page 5. Annexure page
If you
6.
pay interest, that will also go from the pocket of the public. That will also be detrimental to state interest.
Page 53. Kindly. Crores of rupees. Crores. Kindly, I am beseeching to my lord. Kindly interfere. Otherwise, the state interest of the state will be protected. Kindly protect the interest of the state.
Why was it? What is the reason you have given for not depositing?
Reasonable period, my lord. Kindly see.
What is the reason for not depositing in time?
Because, my lord, the
What have you stated in your
Yes,
application? The application which was filed on that date, which was rejected.
yes.
What was the reason
yes,
given
yes,
there? Can 4 appropriate order?
Yes. I am. Can 4. There
Can
was
4 which was rejected.
a can 4. There is no statement, no abandonment.
Then there is no scope of review.
My lord, kindly consider. No, my lord. Kindly consider one thing. Review, my lord, if there is patent error. My lord, the error.
Patent error. There is not even any error.
Error. My lord,
Patent
substantial-
error of the advocate is not a
my
patent
lord,
error of court.
substantial question of law are being involved. My lord, kindly consider that the review. My lord, kindly. Otherwise, my lord,
You are not even required to
My lord,
satisfy the
kindly
court on
pay-
substance. You are not even required to
my lord,
satisfy.
I can. Yes, sorry.
You are not even required to satisfy court on substantial questions of law in a first appeal. Questions of fact are sufficient. You lost that chance. Section 5 was filed, allowed, directing you to deposit money. This was the second default.
Second people, my lord, kindly consider.
No,
Kindly-
this is not a case of review.
kindly, otherwise, my lord, crores of rupees, my lord, public
Will be gone.
My
What
lord,
can be
my
done?
lord, 80,000 or what I have. My lord, kindly consider this. Otherwise, my lord, I will not, my lord, make any submission. My lord, this is for the interest. Kindly, only 115 days, my lord. I could have understood no.
So
step was-
in this application, what reason you have given for
Yes, my lord. Yes.
not depositing?
Yes,
Let us see that.
It is submitted, my lord. Kindly come to.
Let us see the relevant paragraph.
My lord, kindly come to. Fact I have read, stated.
Page 4.
Admittedly, no, my lord.
Eight.
Page 2, paragraph 1A. Admittedly, my lord, kindly consider. Admittedly, LA proceeding for construction of regulation forward colony on the basis of proposal sent by no such and such. A award was declared on 2008. Next paragraph, my lord. Fact remains that the referring claimant has received the awarded amount and sought for deference under section 18 and the respective reference case has been numbered so that the fact remains that the land acquisition of the third court such and such after hearing the submission such and such enhance the compensation to an illegal arbitrary. This is the challenge, my lord, 4-4. My lord, state authorities or the support of justifying the order. Being agreed, the FAT number first of 5. The fact remains that the said appeal and application or had but or such and such at 5,000. Then, my lord, kindly come to page 4. That the fact remains pursuant to such order, Honorable Division Bench separate checks were being issued in the name of High Court Calcutta Legal Services Committee as per directions of Honorable. However, the fact remains that the issuance of checks 750 rupees at the behest of the concerned official was made belated. But it was not pointed out. For substantial justice, my lord, I am beseeching to my lord.
No, Mr.
My lord, kindly. Then, my lord, the fact remains. My lord, kindly, my lord, I am beseeching, my lord, this is, my lord, otherwise, my lord, kindly, for 115 days delay, my lord, I am ready to pay interest as well as, and I have already, my lord, kindly see that all those checks were sold by handing over all those in the name of the High Court. Again, my lord, kindly, checks show to accept.
There is a huge gap between H and I at page 5. H, you say you approached then learned advocate for taking necessary steps.
Yes, necessary steps.
When did you approach? Nothing is stated.
Yes, well, at the time when the application was
Then-
filed, when the
then-
application was filed, before that we have approached with the check.
Mr.
the-
Sengupta,
Yes,
no,
sorry.
you have not stated that.
No,
You have
it says,
stated in
well,
paragraph H. Please read your paragraph H
oh,
instead of
H-
wasting time.
H, my lord, H.
Read H
The fact
for
that
yourself.
the concerned official of the appellant is even approached the Registrar General High Court at the material point of time, intimating internally to the chairman of the Calcutta has refused to accept those checks since issuance of the checks were prepared belatedly. And the official of the
That is your
appellant-
voice now, Mr. Sengupta.
Yes,
Your voice.
voice cannot. No. I cannot raise.
Read it out in your usual voice.
No.
Please read out in your usual voice.
Otherwise,
You love your voice.
No.
Read out in
No,
your
no.
usual voice.
No. Belatedly, and the official of the appellant petitioner was advised to approach the learned advocate appointed in the said appeal. According to the consul official, the appellant petitioner approached the learned advocate for necessary in the fact remains, unfortunately, application for appeal filed on the behavior was affirmed on 14/1/2025. And the
When
said
did you approach the learned advocate for taking necessary steps?
before that, Malad.
You have not stated here.
No, it is not. But Malad, it has approached. Malad,
For 3 years, it took you to take some steps to the office of the advocate and him to draft an application for appropriate order.
Malad,
3 years.
Malad, kindly
Is it
no,
credible?
Not that, Malad, kindly consider one thing. Malad, subject to Malad. Again, Malad, this is mercy. Malad, I am at a mercy of
No.
Malad. Malad, kindly. Otherwise,
You don't
Malad,
have
kindly-
mercy jurisdiction in
No,
review.
Malad, review is maintainable. Malad, kindly.
Review is maintainable. Review is not mercy jurisdiction.
Malad, kindly
We don't
consider.
have mercy jurisdiction. First of all, in writ petition, we extend our hands to protect people
Malad
who
can
require protection,
Malad, can even.
who are defenseless, who are marginalized. Those people are extended
Malad, I
to
will
protection.
pay.
We go all out, Mr. Shenmudra, to give protection to those marginalized people.
Yes, you see,
State is not a marginalized class
Malad,
of
Malad, kindly
category of
kindly
juristic
consider.
person.
Malad, kindly consider one thing. Malad, kindly come to page.
State cannot do whatever.
Malad,
it
yes,
likes.
Malad, absolutely right. Kindly page for 53. Page 53. Malad, again 80,000, Malad, already, that is already in, it can be, Malad, in cash.
You're lucky that we
80,000.
did not dismiss your CAN4 with costs. You are lucky. Your client is lucky that we did not dismiss CAN4 with costs.
Yes, Malad, Malad,
But this review application we will dismiss with costs. There is nothing, no case of review made out.
not
No case of
Malad,
review.
kindly, I will pay the interest also, Malad. Kindly 80,000 plus interest.
We'll record that, but we'll dismiss.
Malad, kindly.
এই পুরো-
Malad, I am
এই
Malad,
শুধু-
on judgment and
এক সেকেন্ড শুধু 8টা দেখাচ্ছেন কেন? সবকটা কানেক্টেড না? কি?
there are 19 appeals. And Malad, out of 1916, Malad dismissed.
What
And
did
three-
we allow by this? Substitutions.
Substitution, no. Then Malad, this is CAN4. This CAN4, that is the same application which was dismissed in other appeals. Malad, I only making a.
No. These were applications for condonation of delay. In
My lord, this
preferring
is-
the appeals.
No, my lord. CAN4 is the, my lord, kindly see, CAN4 is our application.
CAN4 was dismissed.
CAN4 in the appeals have been
Sengupta,
rendered
you have not even
infructuous.
prepared your matter.
My lord,
You're please come to these orders.
yes,
Please come to these orders.
yes.
CAN4, this has been held to be infructuous
Huh.
because the applications for condonation of delay in preferring the appeals themselves were dismissed.
Yes.
Difference between these cases and those cases are there the first application for
Yes.
condonation of delay was dismissed, and in this case You got a more merciful judge than us. At the first instance, Section 5 was allowed. But that was on condition that you pay 5,000 to the legal services authorities for the children in the correctional homes. You did not pay that for 3 years. So we dismissed your Can 4 saying that it was an automatic dismissal because
Yes,
in
yes,
default it was
yes, well, I know.
you sought for a virtual recall of that.
But my lord, kindly consider one thing. May I submit? Subject matter. Again, I am beseeching to my lord.
You have
My lord, my lord, dismiss. My lord, kindly consider one
Sir,
thing. See the fate of the.
It cannot be that till we pass our order in your favor, you will go on arguing. Now, this is not
No,
done
I
in our
cannot. I am not the
You're
person.
precisely doing that.
No,
We are
I
going
am
to
not.
pass-
I am
we
not.
have made our mind clear, so we are dismissing this and we are going to pass our orders. Please don't prevent the court. All the present review applications have been filed in respect of similar orders passed in connection with different appeals preferred from the self-same land acquisition process. Full stop. Next para. By an initial order passed in each of the appeals, applications for condonation of delay filed by the state stroke appellant were allowed subject to payment of costs of rupees 5,000 to the Legal Aid Services Committee for the purpose of welfare of the children in the correctional homes in the state of West Bengal. Full stop. Next para. However, despite such condition being imposed, the same was not the said deposits were not made within the term stipulated, but after about 3 years thereafter. Full stop. Next para. When the matter came up before this court, by way of applications for appropriate order made by the state appellant, we, in the orders under review, had dismissed such applications by observing that it was categorically mentioned in the initial orders that failing the deposit in terms of the order allowing the condonation of delay applications, the respective appeals would stand automatically dismissed without further reference to the court. Full stop. As such, the dismissal of the respective appeals as time barred was automatic in the event of non-payment of the costs within the period stipulated therein. Full stop. Even thereafter, we had recorded, the state appellant adopted an utterly negligent attitude in not taking any steps for putting in the deposit for almost 3 long years. Full stop. We observed that such gross negligence was unpardonable and invoked 2 principles, first, that the state or any authority is not a favored litigant, and secondly, if the applicant in a condonation application is palpably negligent, the benefit of Section 5 of the Limitation Act cannot be accorded to such a litigant. Full stop. In view of such observations, by the orders under review, we had dismissed the respective applications for appropriate order by refusing to recall the order or extend the time for putting in the deposits. Full stop. As a result, the respective appeals stood non-est, being time barred. Full stop. Next para. Learned counsel appearing for the state stroke petitioner in the review application submits that although the respective checks were prepared, from May 2022 onwards till the year 2024, those could not be deposited in time, since there was a minor delay in depositing the same, for which the chairman of the High Court Legal Services Committee refused to accept the checks. Full stop. As per the averments made in the applications for stay filed in connection with the present review applications, the review applicant was advised to approach the learned advocate appointed in the said appeal for taking necessary steps, which was done. Full stop. However, the averments even in the present application are totally silent as to exactly when such approach was made to the learned advocate. Full stop. The averments, thereafter, straight away jump to the fact that the application was affirmed only on January 14, 2025, that is about 3 years after the date of passing of the original order. Full stop. Next para, hence, comma, even in the review application, comma, no reason whatsoever has been furnished for the huge delay of 3 years for making the deposits. Full stop. In any event, comma, the arguments now sought to be advanced pertain to the merits of the or impugned or merits of the order under review and do not come within the contemplation of error apparent on the face of record or discovery of new material as envisaged in order 47 of the Code of Civil Procedure. So thus, comma, we do not find any scope of entertaining the review applications. Full stop. Accordingly, the review applications, comma, as detailed below, comma, are hereby dismissed. Full stop. Consequentially, the connected applications for stay bearing numbers such and such are also disposed of. ওই কোলন দিয়ে যেখানে নিচে সবকটা রিভিউ দিয়ে দেবেন, হ্যাঁ, যে রিভিউ গুলো দেবেন না ব্র্যাকেটে কোন এফএটির কানেকশনে সেটা একটু দেবেন, ঠিক আছে? রিভিউ সাচ এন্ড সাচ এফএটি ব্র্যাকেটে এফএটি, হ্যাঁ, আর তারপর ক্যানগুলো সবই বোধহয় অ্যান হবে।
Obliged.
No rest.
Can one sentence be added? Because they were always, they do.
No, my lord,
Saying this review pending before the executing court to observe, to take time. So kindly add one line. And executing court.
Let there not be a double jeopardy for them. They already dismissed their applications. So. Now you can say that review application is not pending.
No, your lordship has dismissed. That means that we can show the, we can produce this order.
obliged, man.
Thank you. Yes, sir. What is your name?
Rajorshi Ghosh, sir.
Ghosh. Yes, Mr. Ghosh. What is the matter about? You have to only open the matter. What is the matter?
Actually, sir, the last LRTT dismisses the application in 2011.
Take the microphone a bit closer.
LRTT
Take the microphone up.
Lordship LRTT
LRTT, yes.
dismisses application in 2011 after advocating this matter in advocate and die on September 2012. And my client is not aware this law and fact.
This is an application for condonation of delay.
Condonation of delay, Lordship.
The delay is of about how much?
Delay is 2 years, Lordship.
2 years.
Huh.
So your advocate had died after that?
After that, I had filed a application in 2013. And
13.
Restoration.
Restoration, Lordship.
So that was dismissed.
That was dismissed, Lordship.
Why dismissed?
Lordship, I had proper reason and
we will look into that. You have challenged that. He has challenged that dismissal.
Lordship, why the restoration has been dismissed? That is the order under challenge.
Annexure P2, Lordship, page number, Lordship, 68.
Page 16. No, where is the restoration application, Mr. Ghosh? Have you annexed the restoration application?
Page 68.
Page 68, Lordship.
Yes, we'll allow this.
Grateful, Lordship.
2 years, yes. Sufficient explanation was given.
No,
Hyper technical approach adopted.
Kindly Kindly appreciate, Lordship.
Yes.
Your paragraphs 3 and 4 are is the explanation.
Yes.
Page 71.
Yes.
So, my entire blame has been given the dead soul of a lawyer, death of a lawyer and the dead soul. Kindly cease, Miller.
The lawyer might have missed it. They don't blame the advocate. They say
No. Entire plea is that he died. That's why he could not keep track. Kindly means matter is of 2005. It drags on.
2011 it was dismissed for default.
Dismissed for default. 2005 matter getting dismissed in the 2011. So the petitioner does not keep any track of the same. Now it gets dismissed for default in 2011. Thereafter, he comes out of the slumber.
What did he challenge in the original way?
At a vesting proceeding, my lord. Vesting proceeding was under challenge. He in the vesting proceeding, kindly see the vesting his conduct. Kindly see the conduct in the vesting proceeding.
Cannot look behind this dismissal for default. What does it do?
And the state used an opposition also. Kindly see page 18, Lordship. The state used an opposition to the
cultivator. Heard Mr. Ghosh, learned. Your senior is present in court.
No, Lordship.
Has not come to court.
No.
Rajorshi Ghosh.
Rajorshi Ghosh, Lordship.
Heard Mr. Rajorshi Ghosh, learned counsel for the petitioner, as well as Mr. Muhammad Galib, learned senior government advocate. Learned senior government advocate, appearing on behalf of the states. First up, the limited scope of the present challenge is against an order refusing to allow the restoration application filed by the petitioner on the ground that sufficient explanation for the delay in preferring the same was not furnished. First up, next para. The brief facts are that the petitioner had taken out an original application before the tribunal, which was dismissed for default. What was the date for dismissal of default?
Page 76, Lord.
Page 76.
Page 76, my lord. 5th April 2011.
Thank you. Dismissed for default on April 5. Thank you, Mr. Galib. April 5, 2011. First up, thereafter, the application, the present petitioner took out an application for restoration and for condonation of delay on April 30, 2013. April 30, 2013. That is about 2 years after. Which of next para? In the said application, the writ petitioner stated that the writ petitioner had entrusted their his erstwhile learned advocate for conducting the matter. First up, however, subsequently for the first time in the first week of February 2013, the petitioner came to know that the said learned advocate had died in the month of September 2012. First up, thereafter, the writ petitioner tried his level best to get back the papers, but could not collect the papers from the chamber of the learned advocate, and was constrained to file an application on March 11, 2013 for obtaining a certified copy of the original application as well as the last order passed by the tribunal therein. Full stop. Next para. Upon getting the certified copy, it was discovered that the original application was dismissed for default on April 5, 2011, whereupon a new learned advocate was entrusted who prepared and filed the application for restoration. Full stop. Thus, we find that sufficient explanation was furnished in the restoration application and the connected condonation application for the delay in preferring the application for restoration. Full stop. Next para. However, the learned tribunal, while passing the impugned order, took a hyper-technical approach contrary to the settled principles of law governing the adjudication of applications for condonation of delay. Full stop. We cannot also lose sight of the fact that the writ petitioner is a cultivator is an agriculturist by profession, and as such, being a layman, cannot be expected to know the nuances of law. Full stop. As such, the helplessness of the litigant and the marginalized condition and his marginalized condition are additional factors which prompt us to take a more lenient view in the matter. Full stop. Thus, we are of the opinion that the learned tribunal erred in law and in fact in passing the impugned order, dismissing the restoration application of the petitioner along with the connected condonation application. Full stop. Next para. Hence, WP this WP-LRT 124 of 2025 is allowed on contest, thereby setting aside the impugned order dated February 12, 2025, passed by the learned learned second bench. This is the second bench. Not sure. Let us just check up. Learned second bench, West Bengal Land Reforms and Tenancy Tribunal in MA number 317 of 2013 and MA number 318 of 2013, thereby allowing the said applications and upon condonation of delay in filing the restoration application, OA number 3703 of 2025 within bracket LRTT bracket close is restored to its original file and number. Full stop. The learned tribunal shall now decide OA 3703 of 2005 within bracket LRTT on its own merits upon giving adequate opportunity to the parties to present their respective cases. Full stop. In view of the long delay, it is expected that the learned tribunal shall dispose of the said OA within 1 year from the date of communication of this order to the learned tribunal. Full stop. No orders to cost.
Grateful, Lordship.
So you are hesitating to start. You place the entire case and you won the case. Yes. Next.
I am appearing for the petition.
Yes, Mr. Agarwal.
But your lordship will be rising, I believe.
Yes, Mr. Agarwal will come again.
I will be here.
Yes, sir.
My lord, moot question of appeal. With your lordship, my lord, whether
Yes.
a hearing, if is given without so cause notice or without a statement of defense, can be a meaningful hearing.
What the hearing is in context of what?
In context of an allegation that I have shown another plot, whereas my shop is situated at another plot, adjacent plot, in the same locality, in the same place.
Under which provision? This was
No provision, my lord. And kindly see provision they invoked at page 41. Kindly see the impugned order at page 41. Last paragraph. And hence being the licensing authority, last paragraph.
yes.
I am of the opinion that she had suppressed the facts regarding the land schedule, be it willingly or inadvertently. It led to a selection of the inquiry process, and thus I am revoking her license in exercising power conferred upon me vide clause 45(3) of the control order. Now, my lord, I am placing this 45(3).
Yes, we'll record that.
Yes, I have just made one copy. No, two copies.
Mr.
Two.
Supratim Dhar is my lord appearing on behalf of the state respondent, my lord.
Let him appear. We'll decide the appeal, then let him come.
Married, you also married, man.
Yes, sir. Mark that 3.
Marked by the learned single judge.
So that's easier for us. No, this is probably on suppression of something.
Man, that is not, this clause does not apply, my lord.
But they have invoked 3 only.
Only 45(3), nothing more. Lordship, kindly see. And my lord, there was no so-called notice, no document supplied, merely upon saying that you have done this and you have accepted that it was done inadvertently.
What is the nature of allegation?
That my lord, I am reading it out, madam.
Yes.
Whereas it has been primarily reported from area inspector, Nandigram Block 1, video memo number such and such, that the newly engaged FPS Archana Jana had obtained her license through wrong submission of land documents, wherein she submitted a report from the block land and land revenue officer, mentioning that the godowns shown or offered by the Archana Jana during the vacancy inquiry, which was declared video memo number such and such, situated on different DAG number 375 of his character is Jal, instead of her produced or submitted land schedule documents in vacancy, which is 387 DAG number, which is Vastu. This is the allegation, my lord.
And let us see the provision once.
My lord.
Yes, why was no so cause notice? What was the view of the learned single judge?
My lord, the learned single judge held that this clause is not applicable. Kindly come to page 48.
Plot number 387.
Page 48, paragraph 18. This court has also perused the provision of Rule 45(3) of the said control order. It appears to this court that the said Rule 45(3) of the said order with different cases where a dealer is found to be doing an act which is prejudicial to the interest of beneficiary tagged with the fair price of. As rightly pointed out, Mr. Agarwal and Advocate on behalf of the President, that the order under challenge dated such and such is passed under provision 45(3) of the said order. However, this court is of the considered view that mentioning of wrong clause will not dilute the fault of the writ petitioner. But there is no other clause whereunder this can be terminated.
There is no other termination.
My lord, I have got the entire book. If you are, for your lordship certification, I can give you.
If you have checked up, Mr. Agarwal, we will rely on you. They have to show that there is some other. No, please give us a copy of the book once. We will just check up. Please give us the clause which the relevant clause regarding grant of license.
That is my lord.
I will just check up.
In one book, my. Selection procedure is at clause 13. And procedure, my lord, it starts from clause 9, my lord.
All right.
9, 10, 11, 12.
satisfied ছিল like
You're a dealer or a distributor?
I'm dealer, my lord. Dealer.
Page 41.
Yes, Mr. Dhar, you invoked 45.3. 45.3 is for some subsequent action by the dealer.
Kindly first come to the rescind order, which is at page 41.
Come to the which order?
Rescind order, which has been challenged by them before
Yes,
the
that was placed by Mr. Agarwal. Yes.
how they have
shown a wrong go down.
wrong plot to get the license.
Accepted. So, what is the provision under which you cancel the license for that?
Kindly do not go by the nomenclature. Well, if if
there
the
has to be a
license-
provision for cancelling
if
license.
the licensing-
What is the provision under which we are not going by the nomenclature? Where do you get the power of cancelling the license under these cases?
That is inherent. My lord, if I may be permitted to say, my
If
lord,
it's
the
inherent, then
license-
natural justice has to be followed.
if the licensing authority does have the power to issue a license, well, and the person who is applying for the license before that authority,
We appreciate
and
what you are
falsifying-
saying. We appreciate what you are saying. Definitely, there has to be something. If it's not there, we have to read that into. But then we also have to read into that national justice, because a license has been issued. It's not a question of at the threshold you can refuse to give him license. You have granted him license means at the first instance you are satisfied that he has complied. Give him a notice and come back. We'll set aside lock, stock, barrel and ask you to give a notice and then take your call.
Well, today we got this brief. Well, kindly.
Today we'll get the order also.
Well,
So and
I'll be
this
relying
proceeding will
on
be done.
one division bench judgment where, my lord, it says that yes, authority does have the power.
We are not saying it does not, but then we have to read natural justice audio order and part him into that. We'll say that 45.
He was hurt. Well, kindly come to the rescind order once. He has accepted his guilt.
Let us see
Before
that.
the
Oh, hearing.
kindly
Hearing
to
was
page
given without
41.
so-called notice, without supply of any document.
He was there. He was present before the hearing officer. He has accepted his guilt.
Mr. Agarwal, let us come back tomorrow. Come back on Monday. You come prepared. Come prepared on both points. One is your power. Power we may read into it, because otherwise it would be absurd that if somebody commits a fraud, even then you
absolutely. Well, that is
you
the-
cite that judgment. And also regarding this hearing, we have to be satisfied. Mr. Agarwal's specific point is no show cause notice was issued.
No documents have been.
We'll look into that notice. You please try to collect that notice also, the notice of hearing.
And I believe.
Is it annexed here somewhere?
Annexed.
Notice
No.
not in.
No, because the hearing.
Notice of hearing has been given. I was called for hearing only.
Yes, that is at page
Whether in
40.
the writ petition,
Page
that point
40.
was
Page
taken.
39 or 3.
That is
Yes,
also to be seen.
Yes, yes. I have to-
Kindly, direct them to provide the writ petition once.
Why I have given? He was appearing in the writ petition.
Can I annex that?
I have not annexed.
That is not annexed.
Here willfully conducted.
Notun
No, that no.
There is not-
Page 39 notice may come to your benefit when you argue on Monday.
That is hearing notice.
But there the alleged offense was also stated, Mr. Agarwal.
My lord, but no document has been provided. They have not come to the concluded conclusion. They cannot come without the notice. Without the documents, supply of the documents are must. Your lordship knows, my lord, that
The person concerned go before the court and up in the dock and admit
then
his guilt. Well, I'll come back.
You bring
I'll
those
come back.
papers also.
I'll come back.
And whatever papers you will put it on, not on Monday, on Tuesday, so that whatever papers you get, please give copies to him by Monday. Whatever papers you want to rely on, that admitting on doc, other things, just give papers to them, circulate that, and come back on. We'll keep it on Tuesday.
Tuesday.
Appear for the respondent number 5, my lord.
You are.
Respondent number 5, my
Who are you in context?
He is the landlord, my lord, who has entered into an agreement with me for giving that plot. Now he says that it was wrongly done.
In the lease deed, it was wrongly mentioned as 387. Actually, it was given for plot number 375, and the plot was also is existing there.
It's a registered deed.
It's a registered deed and we
Then without rectification, you cannot say that.
can be done. But that can be done.
Affidavit of service filed today be kept on record. Full stop. Next para, learned counsel appearing for the state seeks an accommodation for preparing himself and collecting papers. Full stop. Next para. Accordingly, the matter is adjourned till August 19, 2025, when it will be listed under the same heading. Full stop. In the event the parties want to rely on some other documents than those annexed to the present papers, there shall be a prior circulation of the same on the learned advocates for the other parties.
My lord.
Thank
Deeply. I'm deeply.
And Ms. Agarwal, if you have a copy of the writ petition, bring it on the next date.
I have got my lord here.
Well, bring another extra copies for us. And,
Yes, I'm here.
no, not now. At the time of hearing.
It will be recorded. I'm giving here and now. I've got 2 copies for your lordship.
No, for us on the
Yes,
next.
for your lordship, my lord.
No, come back on the next. Don't threaten us with the writ.
I am ready with that. I was aware that I should have that.
So the writ petitions you bring and whatever
2
papers you want.
copies it will are ready. Well, may I take back the
What was given? Yes, sorry.
deeply.
You bring copies of these also on the
I shall bring copies of the entire 2 sets for this.
better. Yes. That matter.
Yes, my lord.
Yes, Mr. Dev.
Now, my lord, I want to start, my lord, from the point of res judicata. How I overcome, my lord.
Yes.
Now, my lord, if your lordship will, West Bengal Land Reforms Act 14T 3A.
তারপর তলাটাও দিয়ে দিন। হ্যাঁ, ওটা। Sorry, 14?
T 3A. Previously, that was not, my lord, after that amendment was made, and that was, my lord, done. That is the revenue officer, 3A, my lord, capital A. The revenue officer may, of his own motion, and after giving the riot an opportunity of being heard, revise an order made under subsection 3 and determine afresh the extent of land which is to vest in the state under section 14S and take possession of such land.
14 what A?
3A.
3A, my lord.
3A.
3 capital A.
14T, 14T, my lord. 3A, my lord.
Capital A বলছে।
হ্যাঁ,
3 capital A.
A, my lord.
3 capital. 14T 3 capital T. T. 14T capital T.
3 না T।
I know. স্যার, বইয়ে থাকবে তো। তুমি আমার বই দেবে।
সুবিধা
My lord, maybe, may I be permitted to hand over the
14 TA তো।
3A, my lord, 14T 3A.
Yes. Yes. The revenue officer?
The revenue officer may, of his own motion, previously that was not, my lord. After that, amendment was done. And after giving the riot an opportunity of being heard,
Yes.
revise an order made under subsection 3 and determine afresh the extent of land which is to vest in the state under 14S and take possession of such land. Provided that application made to the revenue officer prior to the commencement of the West Bengal Land Reforms Amendment Act 1978 shall be disposed of by the revenue officer in accordance with the provision of this subsection. So, my lord, the authority has the power to revise or modify or anything else, my lord. Previously, that was not done. For that reason, my lord, there are so many points. That, my lord, if my lord, the vesting order has passed, my lord. After that, my lord, a person wants to purchase some land. And, my lord, that is the business of purchase land and selling land. For those purpose, my lord, to stop those purpose, my lord, that is the amendment was done. And, my lord, that point, that is res judicata, my lord, perhaps I overcome that point, that I have that right. My lord, now, my lord, I want to, Now, my lord, I want to, on the previous occasion, my lord, yesterday, my lord, I have gone through the 14T5 and 6, my lord.
Hmm.
Today, my lord, I again, only for this, my lord, I want to read the 14T6, my lord, as because I want to show what is the difference between the West Bengal State Acquisition Act and West Bengal Land Reforms Act. Only to show. For that is, my lord, I want to read, my lord, that is 14T6.
Hmm.
The revenue officer on his own motion or upon any information may, after giving the person interested an opportunity of being heard, inquire, decide any question as to whether any trust, endowment, or institution is of public or private nature, or exclusively religious, or charitable in character, or both, and in any question of title incidental thereto, as may be necessary to determine the extent of land which is to vest in the state under section 14S by examining the documents, if any, or by taking into account the following among others. My lord, what we can do? Actual user of income and usufructs. Who is used that land? Who is getting the usufructs? That was not in the West Bengal State Acquisition Act. Mode of cultivation, how the cultivation was made. Share or income or usufructs of land appropriated or enjoyed, or the area of such land occupied or enjoyed by or on behalf of the manager, Sebait Mutually, or any other person managing the trust, endowment, and institution. My lord, ample power was given by the my lord legislature to by in the West Bengal Land Reforms Act, my lord, and for that is my lord. Now I want to differentiate what is the in the West Bengal Estate Acquisition Act. If your lordship will come, West Bengal Estate Acquisition Act.
Estate acquisition একটা দিন তো ওয়েস্ট বেঙ্গল এস্টেট অ্যাকুইজিশন ব্রাউন ব্রাউন মতো ছিল
Only to differentiate that, my lord.
Thank you. Yes, Mr. Dey.
My lord, section 6(1), well, that is I.
Yes.
Where the intermediary is a corporation or an institution established exclusively for a religious or charitable purpose or both, or is a person holding under a trust, my lord, that is a person, or is a person holding under a trust or an enjoyment and other legal obligation exclusively for the purpose which is charitable or religious or both, land held in trust of such corporation or institution or the person for such purpose, including land held by any person not being a tenant by leave or license of such corporation or institution. There is a, my lord, there is no any inquiry on anything else. Now, when the West Bengal Land Reforms Act comes, my lord, my learned friends' contention that the West Bengal Estate Acquisition Act, that there is the absolute charitable and absolute was declared. So, in West Bengal, we can't. That is, my lord, the state can't come to the challenge that. Now, my lord, I am coming. If your lordship will res judicata point or was also G, my lord. Now, my lord, if your lordship will come to West Bengal, কোনটা বাবা আসছি দাঁড়াও না একটু আমি তো পড়ে এসছি Now, my lord, if your lordship will come West Bengal Land Reforms Act. Now, my lord, previously I have shown what is the difference. For the difference 14T6 and my lord West Bengal, that is 6(1) and I difference. And my lord, how we can go? Now, my lord, I can show that is 14T subsection 8.
Yes.
Notwithstanding anything contained in this act or in the West Bengal Estate Acquisition Act 1953, West Bengal Act of 1954, or in any other law for the time being in force, or in any agreement, custom, or usage, or in any degree, judgment, decision, or award of any court, tribunal, or authority the provisions of subsection 5, 6 and 7. My lord, the 5, 6, 14 to 5, 6 I have read, my lord, previous occasion. 7 shall operate with retrospective effect on and from the 5th day of May. 5th day of May, my lord, was Estate Acquisition Act was introduced. So retrospective effect was given. If anything done, that we can now, my lord, in 9. Subsection 5, 6, 7 and 8 of this section shall be deemed to have always been inserted in the West Bengal Estate Acquisition Act 1953, West Bengal Act Ato, any officer specially empowered in this behalf under the provision of West Bengal Estate Acquisition Act 1953 or under the provision of this act may in exercise of the powers conferred by subsection 5 to 8 reopen, my lord, now reopen and decide afresh any proceeding, case or dispute in relation to determination of total land held by an intermediary or a riot. Previously, my lord, termed as intermediary.
Yes.
Now, my lord, in West Bengal, that is termed as riot. For that is an intermediate riot, both term was used. And determine the quantum of under riot at any point of time, or may determine the quantum of land such intermediate riot or under riot was or is entitled to retain, or may or also may determine the extent of land which is to vest to in the state, or which shall remain vested in the state, and shall take possession of such land in accordance with the provision of section 14 SS. I must come after that, my lord. Notwithstanding, now, my lord, this line is very, notwithstanding any judgment, decision, or award of any court, tribunal, or authority to the contrary, the rule of res judicata. My lord, again, that term was used. Res judicata shall not apply to such cases of reopening or fresh determination. That is my learned friend, my lord, wanted to say and take the grounds. In the grounds, my lord said that once that was declared, can't revise on anything else. And another point is taken that West Bengal second and third notice can't be issued by us.
That was the first point.
That is the what? Yes, my lord.
And the other is that Paschim Banga Bhumijivi.
Now I am coming. Now I am coming, my lord.
So by showing these, you say there is no concept of res judicata.
Yes, my lord.
Because of subsection 9, as well as that this non-obstante clause.
Yes, my lord.
In 8. So 8 and 9 combined.
14T.
Yes.
3A. 3 capital A.
CA.
Specifics stated.
Power to revise.
Yes, my lord. My lord, I am coming on that point, my lord. And later, my lord, I come.
Very.
My lord, I can come.
So,
my lord, if your lordship will say that is a division bench judgment, not a larger bench judgment. Your lordship is not, are not, my lord, bound to.
We are bound by coordinate benches also, unless you refer.
My lord, up to what amount, up to what point? My lord, if that is goes against the statute, that is within the statute, my lord, your lordship can go. And my lord, within the statute, I can go.
No, but Mr. They
lord,
have a point there.
What is 14M? My lord,
no, if it is against the statute, as you say, there may be two kinds of par inquirium. One is par inquirium because it does not take note of the of a previous judgment of co-equal or greater strength.
Only for that reason, my lord.
Or par inquirium since it does not take note of a statute.
Yes, my lord.
Here, the statute itself was interpreted by this judgment. Unless
Yes, my
you take
lord.
a different view and refer to the larger bench.
For that reason, my lord, your lordship. What is 14M? 14M is not based on, my lord, that is the trust or anything else, my lord. 14M, if your lordship will come, 14M.
14M is not, yes.
14M, my lord, only ceiling area. That is how much that is Rayat is 1%, that is will get 2.50 hectares. If a Rayat is Mala 2 to 5, then he will get Mala 5 hectares, standard hectares. And if that is 2 to 9 Mala, then we will get 7 hectares. That is the sum and substance. And 5 and 6 Mala, 5 and 6, what is that done? Well, specifically, what is that done?
Mr. Can you satisfy us that under the Land Reforms Act as it stands now, a deity or an idol cannot be constituted to be a riot? Is it that?
Yes, my lord, constituted riot.
A deity?
As because, my lord, if you
No, a deity can.
my lord, you will
Just let us one by one.
Yes, my
A
lord.
deity can be considered to be a riot in its independent capacity.
My lord, you will now, my lord, if your lordship will come 5 and 6, 14 M.
That can be
5 and
so.
6.
If that can be
My-
so,
my lord,
why
if
should
you-
he hold that Justice Sinha's judgment is bad? Because Justice Sinha says if a riot can hold, a deity can hold a land as a riot in its independent capacity, then why should the deity's land be taken to be also the land of the person who created that trust?
Or-
Because it will be a double overlap. There will be overlap. That same land will be taken for that person as well as the riot.
No, that is not the position of law.
First.
My lord, if your lordship will see,
Yes.
that is 14 M 5, my lord. What is that?
M5, yes.
Yes, my lord. The lands owned by a trust or endowment other than that of a public nature. That is a public nature. If that is a public nature, shall be deemed to be the lands owned by the author. That is the riot.
So
Of
if it's
the
a private trust for a deity or an endowment, private endowment,
that land will be included to the riot.
so for that land, it will not be treated to be the deity's land.
No. Yes, my lord.
It will no or yes.
It will be treated as a riot's land.
So therefore, it cannot be treated independently. For a private trust, it will be treated as a human being's land.
Yes, my lord.
And
Riot's land.
not the private deity's land.
Yes, my lord.
It will not be calculated. The private deity will not be constituted as a riot.
As a riot. Now, my lord, 6.
Then there is no overlap.
No, my lord.
Then the rest follows.
Now, my lord, 6.
Yes, 6 says that.
Notwithstanding anything contained in subsection 1, a trust or an institution of public nature exclusively for a charitable or religious purpose or both shall be deemed to be a riot. Well, he will be a riot automatic.
Only public.
Under this act.
Only public ones.
Yes, my lord.
So therefore, if you read 5 and 6 together, public, insofar as public trusts are concerned,
Yes, my lord.
they will be treated to be riots.
Yes, my
And
lord.
that is the reason for excluding them from 5.
Yes, my lord.
Therefore, if it's public, it's independently a riot. The deity is a riot.
Yes,
But
my
if it's a private trust, deity is not a riot. But it will be added to the land.
Yes, my lord. And for that is under this act, and shall be entitled to retail land not exceeding 7 standard.
The rest follows.
The 7 standard maximum.
The rest follows, because if you say that only public trusts will be riots, then private riots are excluded by 6 itself.
Yes, my lord.
Private deities, they cannot hold as a riot.
my lord.
If that be so, then Paschim Banga Bhumijibi's logic goes.
Only for that is, my lord, I want to, after that, my lord, I want to come.
Please.
That is 5 and 6, my lord, that is clear.
Yes,
My lord,
5 and 6.
my lord, I may not want to, my lord, now I come to my lord. On the previous occasion, my lord, your lordship, one thing.
So this was not considered in para 190 of Paschim Banga Bhumijibi.
Yes, my lord, I may not, only for that is, my lord, I want to show that nobody can go beyond the statute. Your lordship can pass a judgment.
We can hold its ultra vires.
Yes, my lord.
We can hold that a statute is ultra vires.
Yes,
That
my
we
lord.
can
That point was not ultra vires. That section was not ultra, only one section is ultra vires. So, my lord, on the previous, yesterday, I also, my lord, so, my lord, your lordship, if that is a larger bench, my lord, in spite of that, I can, my lord, say something before your lordship. But when this is a coordinate bench, your lordship can go whether the statute is followed by the honorable court or not. My lord, that judgment. My lord, one thing I must now
So,
say.
sir, we have a reservation there because if a statute is not followed, you are absolutely right. We can declare that a coordinate bench judgment is par inquirium because of non-consideration of a statute. Here, a statute was dealt with specifically
Yes, my lord.
and held. Still, we are otherwise bound unless we have an option to disagree and refer it to a larger bench.
Yes, ma'am.
This has already been referred to a larger bench. No, it's before the Supreme Court now.
Before the Supreme Court now. Pending, my lord. That is pending. Now, my lord, another point, my lord, is this.
The state went up in appeal before the Supreme Court.
Yes, my lord. My lord, another point, your lordship. My lord,
Colors have changed, but the fate of the litigation has not.
my lord, another point, your lordship.
was there, my lord, when his lordship, my lord, given the direction to the my lord, state authority to pursue the pursuit, my lord, they are not again. my lord,
ছেড়ে দাও।
Probably Justice Dattu will retire before it is. Yes.
Now, my lord, another point is that, my lord, on the previous occasion, my lord, yesterday, my lord, that in a 14T proceeding, my lord, there is a remark of absolute charitable purpose, that is the absolute devotee. Now I come to that point.
Now, please repeat this point. We couldn't get it. Just take the microphone a bit.
My lord, that is, my lord, that is not correct.
What is not correct? What we could.
My lord, your lordship said that in 14T proceeding, that
14T.
Devotorpopatri was absolute.
Was
Absolute in the written, my lord. My lord, if your lordship will come on seeing the page number 51, 52, 54.
of Pochimongo?
No. My lord, that part, perhaps
What?
I may not want to. Paper book, my lord.
As paper book 51, 54. আমরাও কিছু করেছি না।
My lord, that proceeding was starts as 14T. That is 50, my lord. Now I come, my lord. I should come after that, my lord. 50,
Yes.
my lord.
50 years.
That is the, what is the notice? And my learned friend said that notice is ভূমি সংস্কার আইনের 1956 সালের 10 নম্বর আইন 57 উক্ত তারিখে 14T দ্বারা এবং
Is this 14?
14T
14 বোঝা যাচ্ছে না।
14T3, my lord.
Oh, yes, right.
14T ধারা এবং উক্ত আইনের বিধানসভায় 14CS বিধিযোগের আয়ত্তের প্রতি।
Yes.
My lord, in this, my lord, there is a specific affirmation that you have not filed the জানানো যাইতেছে যে আপনি আপনার পরিবারের পশ্চিমবঙ্গ ভূমিস্খলন আইনের 14T10 ধারা অনুযায়ী কোনো রিটার্ন না দেওয়ার জন্য যেহেতু প্রাথমিক অনুসন্ধানের ভিত্তিতে প্রতীয়মান হয় যে আপনি আপনার পরিবারের সদস্যগণ সহ পশ্চিমবঙ্গ ভূমিস্খলন আইনের 14M ধারা নির্ধারিত জমির ঊর্ধ্বসীমা। My lord, that is the notice 14T. According to the provision of 14T, my lord, every Rayat should file 7A effort showing their lands. But as my learned friend could not produce that 7A to us, my lord, so my lord, we start a proceeding. Now, my lord, start a proceeding under section 14T3, not otherwise.
This is the last proceeding, the third notice.
That is second notice. Third
Yes,
proceeding,
ma'am.
my lord, I come.
Yeah, all right. Second
Yes, my lord. Second
This
proceeding.
was the first notice under Land Reforms Act.
Yes, my lord, Land Reforms Act. That is the first notice. And my lord, according to 14T3, my lord, 3A, now we can go into the another thing. Now, my lord, first, that is the order dated 6/11/90. That is as the Rayat failed to furnish the 7A form, my lord, the case was started. Proceeding was started. And my lord, after that, after the proceeding started, notice was given to him, my lord, according to the provision for natural justice and according to the provision of this, my lord, act. We gave the notice to them, my lord, and proceeding started. And my lord, every 52, my lord, they appeared before the authority. And my lord, 53, I have now come at 53.
53, yes.
Check the land schedule with the ROR. It is found that Riot holds land 19.30 acre in area. Hence, the Riot, along with the family member, wife, are allowed to retain 17.30 acres of land, according to ceiling limit.
We're not getting your color. Yes, you have got it now. Yes.
Which is shown separately in a schedule A, and total land was 19.30. According to the provision of 225, he will get 17.30. So 17.30 was given, separately schedule was shown, and a total quantum of land measuring 2 acres being excess of the prescribed ceiling limit as advised in section 14M. According to 14M, my lord, he will get 17.30. And its subsection under West Bengal LR Act is vested to the state, my lord, which is shown and schedule B with the schedule and part of the other. Now, my lord, quantum of lands are recorded in the RS record in the name of both the deities. Now it is found, my lord, that some quantum of land was found in the deity. And now this, my lord, which are not coming with the, my lord, that was not at the time of 14T, my lord. That was not coming within the purview of this. My lord, this is very important, my lord.
What was that coming within the purview?
Record finds,
yes,
when we going into the 17 acres, 17.30, we are going to annex, my lord, schedule A, that is the retail land, and vested land, my lord, 2 acres. Now it is given, that is page 54. Your lordship will see, quantum of lands are recorded in the RS record in the name of both the deities, which are not coming within the purview of the proceeding. Specific, my lord, stated that this is not within the purview of 14T3. There is other provision is there. For that reason, my lord, that revenue officer, my lord, was forced to write that, otherwise that is, my lord, that will be bad.
So therefore that DT land was not counted as their land.
No. Yes, my lord, that is recorded in the
DT's name.
14T3.
But that was counted to be their land.
No, in their lands.
So
which
afterwards,
are not coming with the in the purview of the proceeding. Canon hoyni, as because this is not under the purview of the 14T. What is that? That is under section 14T, subsection 6. Now, my lord, because those lands have been declared absolute devottor in the Estate Acquisition Act 1953. Not in, my lord, this 14T3 Act. That is the devottor property. It was declared.
And it is also found that income from those devottor properties are not being enjoyed by their family.
Yes, my lord.
So that was excluded then.
All these things, my lord, was written in the act.
So therefore, Mr. Ghosh's argument that this devottor property was also included in the calculation is wrong.
Yes, my lord.
It was not calculated as their land.
Yes, my lord. তুমি বলবে তো এত তাড়াহুড়ো করছো না, এত ব্যস্ত হলে হবে নাকি? তুমি সিভিল লয়ার, তুমি আমার থেকে কত ভালো জানো, একটু বসো, আমি একটু বলে নিই, নাহলে ভুলে যাবো।
All right.
Now, my lord, I am coming, my lord. Now we start. Revenue officer said, this is not the purview of 14T3. For that reason, it is not possible for me to add those things. Or now, what is the provision? My lord, if your lordship will see 14T6.
6 is the inquiry provision.
Yes, my lord, inquiry provision. And my lord we issued the notice, that is 62. That is top, my lord, 3 lines, suo motu proceeding was ato.
Which
Now
page?
we can start suo motu proceeding
This
in
page?
now
Page?
page 62.
62, yes.
Top 3 lines, my lord.
Hmm.
Now we start the proceeding.
This is that so-called third notice.
Notice.
Ah, so this was the inquiry.
Yes, my lord. We inquired the matter, everything according to the provision of 14T6, my lord. That is the term. Who is
But
using
you
that.
say your finding on the previous occasion, on the second notice, that this is, they are not enjoying the usufructs.
Whatever may be that, my lord. That is 9.
You
So
specifically exclude.
all the things we can, my lord, overcome. As because, my lord, 14T9, my lord, notwithstanding anything contained in that. Everything.
Restricted does not apply. Restricted does not apply.
Yes, yes, my lord. That is, we can overcome all the points.
That virus of 9 should also be challenged. Can you say restricted does not apply?
My lord, all the points challenged, but not that nothing was done, my lord, only for the compensation part was, my lord, ultra bias.
True.
My
Therefore,
lord,
even if you go by Poshimabanga Bhumijibi, 9 was not struck out.
yes, my lord, that is only struck out, my lord, compensation. That is nothing else, my lord, 14B, nothing else, my lord. So, my lord, 14T3, my lord, revenue officer said, this is not the purview of those deities land. So, my hands are tied. So, my lord, we disposed of the thing, my lord. And, my lord, now we start the proceeding. That is 14T6, my lord, according to A. And that is, my lord, 62. And after passing all the points, my lord, that is the
Inquiry, hearing,
my lord, order was passed. He filed an appeal. After that, my lord, he goes to the, and my lord, he, that is the order was given by the tribunal, against which, my lord, my learned friend came before your lordship.
What about this page 54? It was held, which are not coming within the purview of the proceeding, because those lands have been declared absolute devotur in the EA Act 1953.
View of the purview. What is the purview? What is the notice? Notice is, my lord, 14T3. My lord, if your lordship will.
Yes, notice
Notice is for 14T3. What is
this
14T3?
concept
Only
of,
the
what is this concept of absolute devotur? Let us
concepts
come
of 14T3, my lord, if your lordship will see. What is concept? 3, my lord. That is, the revenue officer may 14T3, my lord.
14T3 is different. Yes, revenue officer may.
My lord, only calculation of the author. Not, my lord, that is he can't go into the see whether that is endowment or trust is or debt is within the purview of author. That is in the purview of section 14T6, my lord. Only for this reason that line was there, my lord. Only for that reason, my lord, that line was there. Otherwise, that line will not be. Which are not the name of the both the deities. In the arrest record, there is, my lord, that is name of the both the deities, which are not coming with in the purview of the proceeding. Purview of the proceeding, my lord, 14T3. So my hands are tied. So, my lord, because why? Because those lands have been declared absolute devotor in the East Bengal Estate Acquisition Act.
Understood.
And, my lord, after that line, that is the.
And then immediately you undertook an inquiry, and the third notice was not under section 14.3. It was under 14T6 now.
6, my lord. I can go. And, my lord, if I want to go in 14T3 in another procedure aspect,
That
I
also you
can. I have that. That's because
you can revise and notice.
Yes, my lord, that is subsection. And, my lord, if your lordship will see his grounds. Now, my lord, I come to the grounds.
Yes.
First ground, my lord, my learned friends, that is the learned tribunal are in law in holding that there cannot be successive determination of nature of devotor. First point. That is the West Bengal Estate Acquisition Act. That is a declared the devotor, absolute devotor. After that, we can start a proceeding in West Bengal Land Reforms Act that should not be done. That is odd. I say, my lord, that is not correct. And my lord, for that the learned tribunal add in law holding that the nature of Devottar, having been found to be absolute Devottar of public nature, the revenue officer was not otherwise competent to initiate a fresh proceeding for determination in the nature of the proceeding. Second round, my lord, I have shown that we have that right. And third, my lord, for that the learned tribunal acted illegally in holding that the earlier finding by the revenue officer was irrelevant and not having been made in the properly framed proceeding, notwithstanding the fact that despite of the fact that the judgment, even if not strictly legal, is final and binding upon the parties and in the event, and the same cannot be treated in law. So, my lord, that is not. Now, my lord, for that the order passed in the earlier proceeding, including the auto, not having been challenged before the superior court, and the same became final and binding the revenue officer by initiating a subsequent proceeding, cannot avoid its consequence. We are not binding for that, my lord. That point is not, my lord. That point was also not, my lord. That is not a relevant point, my lord. That for that the learned tribunal acted illegally in upholding initiation of a case of auto when the proceeding initiated earlier, the nature of Devottar was properly determined, including in public nature, and as such, a revenue officer in otherwise stopped and cannot initiate a fresh proceeding. My lord, all the grounds are similar, my lord. And my lord, perhaps we have overcome all the grounds, my lord. I may not want to go all the grounds, my lord, but the similar grounds is that the main point is that whether the state can pass an order of absolute Devottar, and that in the West Bengal State Action Act, and that can be modified or can be in the West Bengal Land Reforms Act or not.
And in Paschim Banga Bhumijibhi, while in para 190, the court held that irrespective of whether it's a private or a public trust, if it's independently the DT is a riot, then that cannot be calculated, added to the riot's land. But that proposition you are saying is wrong, because the court did not take into consideration the effect of section 14M6, which says that public trusts are only treated to be riots independent.
And get the same. That is the maximum.
Maximum. So therefore, thereby by specific exclusion, private trusts are excluded from the purview of riots.
Yes, ma'am.
That's an obvious implication. If only private trusts, public trusts are permitted to retain,
yes, madam,
become riots, then private are not included. So that logic of para 190 does not apply to private.
Yes, madam. For that reason, 14 M5 and 6, my lord, that is clear.
5 and 6 to be read together.
My lord, that read together, and
Yes.
that is, my lord, very clear for that, my lord.
All right.
My lord, perhaps I have.
You have covered all the.
Yes, madam.
Yes, Mr. Ghosh. You recovered the points
Lordship, kindly see that
in both senses.
it is not correct that section 14 M5 has not been taken into consideration.
In Paschim Banga Bhumijibhi.
Yes. But page paragraph 187 kindly, my lord, one see.
Para 187.
Public nature, my lord, it has been quoted. Section has been quoted. Paragraph 187. Thereafter, it has been
14 M6 has not been considered.
no, but here, my lord, section 14, there, public nature, my lord, the same thing has been repeated in both 5 and 6.
No, there is a big difference, Mr. Ghosh. 5 and 6, if you come to 6 clearly denotes that public trusts can hold property, and the ceiling has been delineated, demarcated at 7 standard hectares. Therefore, giving recognition to public trusts as separate riots. If that was taken into consideration, then there would be a clear distinction between the scenario under the scenario as held in para 190. Nowhere you see 14M6 is considered. 14M5 says lands owned by a trust or endowment other than that of a public nature shall be deemed to be lands owned by the other. 5 has to be read with 6.
Yes.
The court says, division bench says, no, 5 cannot be correct because apparently 5 has not been struck down, but said cannot be correct Because whether it's a public or a private trust, if it holds land as a riot, then how can there be an overlap with the property? But 5, therefore 5 says that lands owned by a trust or in other than that of a public nature shall be deemed to be lands owned by the author. So by virtue of this, private trusts have been held to be owned by the author.
Yes.
But 6 says that only public trusts can hold property.
Yes.
Therefore, if you read together, public trusts can hold property by necessary implication, private trusts cannot. If 5 is read, in 14M5 is read in that context, the distinction will be clear.
5 and 6 are same. Only thing, what is the quantum?
No, no.
Kindly once
We are telling you this. You listen to us and then.
Yes,
then
my lord.
6 demarcates. 6 says that public trusts will be treated as triad.
Yes.
In a sense, because they will be able to hold land and otherwise. And 5 says, that's the distinction. 5-6 says private trusts will be deemed to be the land of the riot who created the trust.
Yes.
Therefore, for private trusts, it is the land of the riot, the human agency. But for public trusts, it itself can hold property. Therefore, that distinction is made in 5 and 6. Now let us read 5,
Yes.
5 and
My
6.
lord, kindly read 5. The lands owned by a trust or endowment other than that of a public nature. Here, Lord, clarified it.
This is 5.
Provision 5.
5.
Other than public nature.
Exactly.
Shall
That
be
means
deemed-
private.
That is private.
Shall be deemed to be lands owned by the author of the trust.
Author of the trust or endowment, and such author shall be deemed to be a riot. And
The rest follows automatically.
Yes.
So therefore, private trust.
Distinction is whether public or private.
Yes. And
Lord, if it
private
is
trust-
private, then Lord, according to this section, it will be calculated
counted in
with
the author.
author.
And 6.
6 is not, that is how it can be, if it is accepted, this proposition is accepted, then Lord 6, he will be entitled to retain public trust only 7 hectares.
6 is different. 6 says, notwithstanding anything in 1, a trust or an institution of public nature exclusively for a charitable or religious purpose or both shall be deemed to be a riot under this act. Therefore, in case of private, as per subsection 5, it's not deemed to be a riot. It's deemed to be a part of the human's land. But 6 says it will itself, public trust itself will be deemed to be a riot. Now, if you come to para 190 of justice, this judgment.
Lord, before coming to that, your lordship kindly section, notwithstanding anything contained in subsection 1.
Yes.
That is, Lord, subsection 1 relates to ceiling limit.
Yes.
Yes, 1M, M1.
Because it's given 7 is given.
But 7 is given, that is
No, we are, that is the other part of the subsection. Mr. Ghosh, you are highlighting 7. It's excluded. Non-obstante clause is there to distinguish from 1 because the amount given is 7 standard acres given.
Yes.
Standard hectares given. But the other limb of subsection 6 says exclusively shall be deemed to be a riot under this act. That is what clinches the issue for them.
Trust or an institution of public nature.
6 says, notwithstanding subsection 1, a trust or an institution of public nature exclusively shall be deemed to be a riot under this act and then entitled to hold such and such land, which is a niche carved out of 1. And now if you come to para 189 of Justice Sinha's judgment, it says there cannot be any doubt that an idol created under a trust, be it private or public in nature, is a juristic person and is capable of holding property. Where a person dedicated its property in favor of an idol by creating a private trust or a public trust, the idol becomes the owner thereof. The same would be the position as regards charitable or religious trust. Now, in terms of the provisions of the West Bengal Estate Acquisition Act, idol comes within the purview of the definition of intermediary or tenure holder, because there was no distinction between private and public in Estate Acquisition Act. Its position is the same in the eye of law as that of any other intermediary. In relation to the lands which are permissible to be retained under the Act, means the Estate Act, it becomes tenant under the state. Now, therefore, this is in the context of the Estate Acquisition Act, where there was no distinction between a private and a public trust, as Mr. Dev pointed out. But that distinction has come in by virtue of this 14M6. Public trust is now a riot.
Lord, your lordship kindly paragraph 190, may I read it as a whole?
189?
190.
190, yes.
And an author of a trust might have dedicated the properties in favor of an idol by creating a trust long back. These sebais or trustees may be outsiders. The said act does not contain any provision of vesting of the estate of a riot, which would thus include an idol or a private trust. Lord, here it has been discussed.
That is the Estate Acquisition Act.
Lord, yes, Lord, I am telling that for the purpose of here, Lord, the said act does not contain any provision of vesting of the estate of riot, which would thus include an idol or a private trust.
Precisely, yes.
Not there. There it was not there. But for the purpose of sealing area, therefore the idol cannot be divested of its properties, and the author of his successor in interest cannot be deemed to be owner of the property. Under the constitution, a riot is entitled to full compensation in his lands within the sealing area are acquired. If such a provision is given effect to, the same would become self-contradictory. However, there cannot be any doubt that only in a given case where a private trust has been created in order to avoid sealing limit, the appropriate authority may become entitled to tear the veil with a view to find out as to whether the trust in question is a genuine trust or not.
Suppose this does not come in, because this is entirely in the context of Estate Acquisition Act. Estate Acquisition Act had no distinction between a riot vis-a-vis private and public.
Lord, that's why distinction in Estate Acquisition Act, that's why their lordships have held that whether it has been in order to avoid sealing limit, if something is done, that should be inquired into.
That had been carved out by the even in the Estate Acquisition Act, there is no such distinction also. Whether it's a public or a private trust, it's a riot under that act.
Yes, that is.
But in Land Reforms Act, the position is different. By dint of 14M6.
Yes.
5 and 6 read together clearly shows that 5 excludes.
Lord, that is why this discussion.
This is discussion regarding Estate Acquisition Act, which is a different statute, where there was no such distinction between public and private vis-a-vis becoming a riot. That distinction has been introduced in 14M 5 and 6, and as Mr. Dey rightly pointed out, it has been given retrospective effect to the zone of Estate Acquisition Act also. So now this inquiry is under this act, Land Reforms Act, where there is a distinction, and this Paschim Banga Bhumijibi is not applicable in the present case at all, because here the paragraphs you placed were all in connection with the Estate Acquisition Act, and we are speaking about the Land Reforms Act. So therefore, we need not even distinguish this. It's implicitly distinguished because it's about the Estate Acquisition Act.
Lord, your lordship, then one paragraph 192 was also that quoted the decision of the apex court, 191 also. For this purpose only. Because Lord, your lordship recently also knows West Bengal Premises Tenancy Act 1997, Lord, definition 2G.
We cannot compare between an apple and an orange.
Here also, Lord, that has been
used by the Supreme Court, not by me.
No.
Cannot compare between apple and orange, used by the Supreme Court.
Lord, here the coordinate bench has quoted all these judgments.
We have to look at the statute which is in our hand.
Yes.
Land Reforms Act.
Yes.
Land Reforms Act carves out a clear distinction between private and public trusts vis-a-vis riotship.
Yes.
Whereas private trust is not a riot, but the land is counted as the human author's land. A public trust has been treated to be a riot, having 7 standard hectare ceiling.
Yes.
Combined operation of subsections 5 and 6 of 14M.
Yes.
That is not found either in the Estate Acquisition Act or any other perimeter statute. Therefore, we have to go by this statute, and Paschim Banga Bhumijibi, the relevant portions which I have stated are only on Estate Acquisition Act.
Lord, your lordship, then your lordship will have to read more.
And court has not held these provisions to be ultra vires.
That I know. That I have seen, Lord.
There is a reason
but
for
Lord,
that.
Your lordship will have to go down further. What has been held? Distinction, Lord. This section 5, subsection 5 and 6.
Where is that?
Lord, your lordship, kindly let us proceed with the other paragraphs.
We'll continue after the recess with this.
Yes.
Yes, Mr. Ghosh.
Your Lordship kindly grant me some time, Lord. Your Lordship consider this judgment because in paragraph 177, 14M has been dealt with. I could not find out it, Lord. In paragraph 177, kindly see, Lord, the division bench has held that we have dealt with section 14M at a short span of time. I could not find out. That apart, Lord, the paragraph, this has been dealt with, Lord, regarding the question of 189. This is the question of this act, not estate acquisition, because 210 has been referred to. 210 is only definition of riot in this act, Land Reforms Act. Lord, Lord, kindly grant me some time, Lord, so that I can clarify everything. Because this is a question, Lord, to be said.
Come back on Monday then. Substantially heard.
Because no, my Tuesday, my Lord, kindly. Monday, another matter.
Substantially heard, learned counsel for the parties, full stop. On the prayer of learned senior counsel appearing for the appellants, comma, for conclusion of his rejoinder reply, comma, let the matter be postponed till August 19, 2025, when it will be listed under the same heading.
Right.
It's substantially over, Mr. Ghosh, only on this point, just
Lord, yes, Lord.
don't reopen the arguments, just
No,
only-
I am not repeat, Lord, but only thing clarify that.
Yes, this judgment. Right. It
But this relates to that Shalimar oil.
Yes.
ওদেরকে বলো বোতল ফুটো সব লাগবে কোথায়?
For that. Yes.
But I'll first keep it within a very short compass and try and knock off his points, not without getting into anything. Lord, my learned friend's argument, if your Lordship Lord remembers, Lord, almost 90% of his argument was based on that there cannot be infringement. Because one, I don't have registration of the shape, I don't have registration of the color,
yes,
I don't have this, I don't have that, there's disclaimers. So, Lord, 90% of his argument was based on infringement. Now, Lord, my simple short submission is that entire argument is irrelevant because
passing off.
Yes, because there is no order in infringement and there is no cross appeal by me. So it's purely academic, Lord, argument your Lordship has heard. None of it is relevant for our matter. The order passed is on passing off. There is no order passed on an infringement. So your Lordship is concerned only with the passing of action. Now, if that is correct, Lord, number one, what my registration was, what it did not have, what would have happened under the old act, what happens under the new act, all irrelevant. I'll show your Lordship's judgments on that also. Number two, Lord, he said there's some disclaimer of this, there's a disclaimer of that. Therefore, you can't claim this, that, or the other. Not again, a disclaimer is not relevant only to an infringement action.
Only for
an infringement action. It is irrelevant for a passing off. I'll show your Lordship these judgments on that, but I'm putting it in a very short compass. So, my Lord, 90% of his arguments go. Now, my Lord, coming to the, I'll not cite the judgments on that. Or, my Lord, let me, my Lord, first put that also, my Lord, within a short compass. And, Lord, if your Lordship takes the Trademark Act once, my Lord, at a copy of my Lord. Lord, if your Lordship just, not one subsection I'll trouble your Lordship with for the time being. Lord, if your Lordship takes section 27, subsection 2. And there are judgments, Lord, of the Supreme Court which cover this aspect, which I'll just not cite one or two paras from that later on. But, Lord, if your Lordship sees 27.2, nothing in this act shall be deemed to affect rights of action against any person for passing of goods or services as goods of another or as services provided by another person or the remedies in respect thereof. So, common law passing of action not affected by this act. So, Lord, 90% of his argument straight away goes because all of it was based on the act, the registration process, what the Trademark Office says. Lord, he showed the manual, that to get color registration and to get bottle registration, you have to apply in a particular way. What is a trademark within the meaning of the act? All that, my lord, goes straight. Now, my lord, in case my learned friend wants to say that there is a order passed on, my lord, the impugned order is based on infringement and passing off, let me just show your lordship the order. Or I'll just put it shortly, not the order confirms an earlier interim order. The earlier interim order is an order in terms of prayer B, not which is only passing off. I'll just give your lordship the page numbers.
Page 143, volume 1.
Now, if your lordship first comes to page 143, volume 1.
Volume 1. Thank you.
Or I can read it out for your lordship, not whatever suits your lordship.
Page 143.
Prayer B is what was granted.
Yes, yes.
An injunction restraining the respondent, servants, agents, assigns, and or anyone claiming on his behalf from passing of his goods. So this is the prayer which was passed. We are not concerned with infringement in any way or manner.
16th August ad interim order টা দেখান, that is
No,
page
no,
544.
no. Before that, first show it from the impugned order.
হ্যাঁ, সেটাই বুঝলাম।
My lord, if your lordship takes the impugned order, page 834,
volume 5.
volume 5. What that is some-
হ্যাঁ,
আমার কাছে আছে।
What baat করতে হবে?
আমি খুলে দিচ্ছি।
I'll get it.
এই যে,
And if your lordship straight away comes to page 834,
834, yes.
my lord, 834, para 17. Last sentence in that, the ad interim order of 16th August is hereby confirmed till disposal of the suit.
Yes. And what is
Lordship has
that
got
order?
that? Yes. Now, my lord, if your lordship will take, lord, page 576, which is at volume 3.
না, 544 আছে।
Oh, 544.
হ্যাঁ।
How much of 570?
Stars 544 এ নিন, at আপনি এখানে আসুন। প্রথম কথা 544। হ্যাঁ,
Lord,
এখান
the
থেকে
order starts at page 544. I won't trouble your lordship. If your lordship,
546 এ দেখান, it was pressed also, grade B was pressed।
ছেড়ে দাও
হ্যাঁ,
না।
ঠিক আছে।
Lord, if your lordship sees page 546, right on top, 546, right on top. Plaintiff prays for only prayer B.
Yes. And that is granted at
And
page
that is what is
549.
granted at lord, page 500 and
549।
549,
Yes. Yeah, there.
para 12.
Yes.
So, my lord, we did not ask for an act, not order on infringement. We asked for an order for passing off.
You had also asked for infringement probably, but that was not
No, it
granted.
was not
in-
prayed. No, it was not prayed for. Did not ask for. Your lordship has seen. I've showed you.
Oh, yes, yes. Not pressed. 546.
So, my lord, this is the long and short of it passing off.
Yes.
Now, my lord, again, still keeping it within a short compass. Now, within this appeal, my learned friend, my lord, filed an application, which is can number 3. Now, saying what? Saying basically that I want to change my label. This is his application. So he changes his label. But please bear in mind the earlier one has been seen to be passing off. It's been restrained. He comes up in appeal. The appellate court did not state. Stay is refused. Thereafter, he files this application saying, I'm changing my label. And that is what my learned friend was trying to show your lordship. This is my new bottle. This is my new bottle. Now, my lord, please have a look at those bottles. Just give me your bottle. The old bottles. The old bottle.
Can 3 has been filed in this appeal.
Yes, yes, yes. Lord, I'll take your lordship to it in a moment. I'm just trying to, no, I don't want the new. Give me mine and his. This is একটা দাও না। Very well. So, my lord, I'll just keep it apart because, my lord, the test, as your lordship knows, it's not a side
Not
by
to be
side
kept
exam.
together, yes.
Side by side, but be that as it may, my lord, your lordship will see this was what it was. Not different sizes, but not this is really what it was. So there will,
Which was?
but one is his, one is mine. This is mine. Now I have smaller bottles, so does he. He's got larger bottles. At the moment, not we don't have the comparable size,
All
but
right.
this is what it was. This is what has been restrained. Now, my learned friend then says, give me his new bottle. Now he says, I'm changing it. So please permit me to use this bottle. This is really his case. He says, look, you have no monopoly on the color yellow. The names are different. I have changed the red or the brown background now to blue. This is his case. So please permit it. Now, within that, not very short submission before I actually get into not the merits of the matter. Now, leaving all the malafides and the suppressions in that application aside, not the court below was concerned with the first two bottles which I showed your lordship.
All right. Yes.
The court below says, look, this is what you are restrained from using. Now, I'll show your lordship some very interesting judgments because of the interesting language used in it. It says that if someone wants to change their get-up during the pendency of the suit, your lordship is to ignore it. Because it is not the subject matter of the suit, number one. Number two, Lord, he wants to change it, he's free to go do it. He'll leave me free to file another against him or to file for contempt if it's deceptively similar. But your lordships are not acting like a advanced tax tribunal, ruling in advance whether a proposed new bottle will be infringing or passing off. That's not the scope of this inquiry. And that's what, Lord, I'll show your lordship high authority.
And that will be granting them authority to use that.
Correct.
And that thereby precluding a subsequent suit.
Correct. Correct. Lord, absolutely. He knows that this would fall within the mischief of the earlier order. The new one. He wants an advance ruling, although let's say the order says he is restrained from using this bottle or anything deceptively similar thereto. So it would fall within that. Now, it is no part of your lordship's job to not look at all his new artistic designs, rule on it. Yes, this looks good, this doesn't, this will deceive, may not deceive. It is not part of the subject matter of what was there before the trial court. Nor is it the subject matter of the suit. This is how courts have dealt with it.
There's also a green bottle, which they have not said anything about.
Yeah.
Because green bottle का देखिए चला कौन था?
हाँ.
They had produced it, asked them to show.
So
the
the green to the
First day तो ही नहीं है इसलिए.
हाँ. हाँ, शोन, मिट्टी को तो बोल देना, दे.
They're suppressing the bottle.
Yes, there's a green bottle also, which they showed on the last day. Now they're claiming that they've given it to me and I've consumed it on my head.
Not this one.
Right, your lordship can see all of them must have used good quality coconut oil because they've got more than on this side. Yes.
No. Trying to
Now
monopolize over whip cure.
That's okay.
Indigo, orange, red.
Lord, you had your whip cure. You had your whip cure. Now, Lord, let's
Whip cure is the order of the day.
So, Lord,
Rainbow and whip cure.
Makes it white.
Lord, he copied
Makes it
that.
white.
Ultimately white, yes. Scientifically, yes.
He copied that. He also copied our other.
Which one is yours? Oh, yes. Sin.
So
that was the purpose of
this
showing.
can't be coincidence.
That question.
This can't be coincidence. But it's not whip cure now. My label, my color, my get up.
Green, yellow, any other color?
Not yellow and red.
Green, yellow, yes.
This one
base
is
base
green,
colors are green and yellow.
This is green, blue, and white. Both of them using green, blue, and white.
All right. Yes.
That one was using red, brown, and white. So, it's not a coincidence. Hey, take to Rakchi. এটা রাখছি ইউজ করতে পারবো না তেল নেই
ওটা নিয়ে নেবেন না প্রোডাকশন বন্ধ করিয়ে দিয়েছেন আমাদের তো কপি লাগবে
So they sell those.
Well, leave it here for the time being.
That will adjust it from the fees.
Now, Lord,
those are full bottles. No, must not be.
Lord,
those are
empty.
Yes.
Now there is also empty. There is also empty. Now, so Lord, this is not coincidence. Number one. Now I'll show your lordship even more. Lord, please take can 3 and the opposition to that. Like I said, my learned friend made marvelous arguments. But my learned friend made really good arguments, but that would be appropriate in a case of infringement. I would have dealt with it.
অপোজিশন আছে হ্যাঁ রিপ্লাই আছে যখন অপোজিশন আছে
চলে গেল
পুরি হ্যাঁ আমি যাচ্ছি একটু নামছি
yes can see
yes ma'am now my lord 3 points your lordship will remember he has made very strongly.
Yes.
One is edible oil, one is hair oil. I've heard this not repeated 25 times over. Now that your lordship will find in para 3. Your petitioner states that though in respectful submission of a petitioner there is no likelihood of confusion or deceptive similarity in respect of products in as much as, please marks it, as both the products are essentially different and fall under different classes of the Trademark Act. Now this class also becomes immaterial because this is not an action for infringement.
yours is hair oil and theirs is edible according to them.
I'll show your lordship what it is. Forget what he says. Lord, it's easy for a counsel to say something. I'll show your lordship what it is. So he says they belong to different classes under the Trademark Act.
Yes.
But that will only have effect in an action for infringement. Irrelevant in a passing of action. That's number one. Then, my lord, he says he proposes to use a modified color scheme. That's the same para. The rest of the lines.
Yes.
Then, my lord, your lordship sees para 4. Mine is edible, his is not. And he gives photographs. Now, my lord, please take my opposition. Very important. Because my learned friend actually has no answer to what I put in my opposition. So give me that page.
22.
But please
give us just half a second. Opposition will
no. The different bottles.
Can see the opposition can
see that all the products.
আচ্ছা ওই comparison
আচ্ছা আচ্ছা
এখান থেকে starting from 6.
Thank you.
Oh, sorry, reply. Where's my opposition?
এখান থেকে দিলাম
Achha, okay. Now please take page 6. And there's their website also.
সেটা পরে আছে
Now, Lord, please see what he does. Lord, he's talking about Vibjor. Please see his Vibjor now. He copies every other manufacturer in the market. Lord, please see page 6. So on the left side is KMP Ayurvedic Thanda Tel. Right side is Navratna, which is not Imami, the leading. Not so he copies that. Next one, KMP Amla, Dabur Amla. Then, my lord, please turn the page. KMP Coconut Parachute. Now, my lord, please see how he copies the shape of the bottle also. Even the droplets, my lord, you can see he is deliberately trying to put in some little distinguishing feature. But he is taking the entire get-up of every other manufacturer in respect of different varieties of oil. Then, my lord, page 8. Jasmine oil, and then my lord, KMP in Shalimar. Please see, my lord, my 2 bottles and his 2 bottles. So, my lord, this is conscious, dishonest attempt. Lord, oh, your lordships have a color copy or not? Yes. So, Lord, so this is a man who is deliberately copying everyone's products. This is deliberate and conscious. This is not a coincidence. Now, if that be so, some explanation has to be forthcoming about how he chances on the same color scheme, same get-up, same shape, same everything. The law says that in the absence of an explanation, Lord, your lordships will straight away, Lord, prevent this happening because the court then presumes dishonesty. Not judgments I'll show on that, but I'm just formulating the point. Now, the second point my learned friend had been harping on, edible oil versus hair oil.
Yes.
His is hair oil. He says it's a different product. Yours is edible oil. Now, Lord, please let's also not get rid of this theory. Again, Lord, take my opposition, please. I'm sorry. Lord, one more thing, Lord. From that same affidavit, if your lordship comes to page 16, 1-6. Or just so that he doesn't say that those products are not his, this is taken from his website. These are all his products. And those are the ones which I've showed in the chart. Your lordship keeps hearing his factory is shut. With an injunction on this, his factory is shut. Look at the number of products he has.
These are current 25th January.
It's his.
23, 25th January 23.
Yes, so Lord, there's no injunction on the rest. Why should his factory be shut? Unless it is 99% selling my product. And that's what I'll show your lordship. This is his website, not mine. He's proudly displaying the fact that he's copying everyone.
Facebook page.
Yes, Lord, I don't know. I don't do Facebook. Yes, Facebook.
I also don't do Facebook. I did before I was become a judge.
Yes, your lordship is right. This is Facebook.
It's written there. Facebook.
Yes,
That's
Facebook.
Lordship did have a profile.
Now,
Lordship did have a profile.
Yes, it was suspended, but it's limbo now. I did have a profile. The day before I took oath, I had that, but I
Suspended.
Lord, it's
stopped
not,
operation.
I believe your lordship can't go out of it, even if you want to.
No, you can.
You can.
You can.
Keep it suspended. So তাই জন্য প্রবলেম হয়ে গেল না ফেসবুক ফ্রেন্ড অফ
Now, Millard, this different product. Now, let's also bust this theory.
Yes.
Now, his balance sheet. Now, Millard, on the same affidavit, I've annexed his balance sheet. Now, Millard, if your lordship would come to page 21. 20. Page 20, Millard, it's his director's report. And if your lordship then comes down to page 22. Now, Millard, if your lordship has come to page 22, refined edible oil, 98.8%. So, where is his hair oil? Herbal hair oil, 1.2%. And Millard, I'll show your lordship what that herbal hair oil is. It's not this. It's not this. Your lordship has seen all those 5 other products. Those are herbal hair oils. So, Millard, this entire story one has been hearing now. And Millard, please go and see the next year. Millard, it changes further. Millard, please come to page 23 for the next year. And if your lordship comes to page 25.
26.
At 26, I'm sorry, Millard. Please see, Millard, under the heading edible oil, 99.41%.
The director's report.
Injunction is from 22.
Injunction is from 23.
So, Millard, this entire story made in argument completely contradicted by his own documents. This entire sob story, my factory shut down, this, that, and the other. Now, my learned friend also tried to say, I have VIB, GUIOR, every color under the sun I monopolize, etc. Now, and the other point he had made was, common to the trade, the entire world is using the same getup. One has heard that also. Now, Millard, I have not seen a single Millard case where the same getup of any manufacturer not worth the name. But Millard, show it. I'll show you again. Come.
You were showing on the last occasion also.
Yes. Yes. So let me see those bottles now and not get rid of that theory also. Now, number one, the law is that even if there are 10 other copiers, it's not my job to go and catch every small one in the market. I'll show you a lot.
Just because you don't catch the others, that does not mean that you
correct. So, my lord, that
That
is
is-
the
that
simple
is-
my lord, theory behind it. But please, let's see, my lord, the ones he's saying, and my lord, see the names. He made it sound like
one of your juniors are carrying one bottle each.
But Mr. Ghosh had briefed me in some other oil matter long time ago.
Justifies the number of juniors on both sides.
Lord, it would have at least justified, well, Lord, a lot of hair on the head, but the two of us, well, don't seem to have
You are
got
on
the
the
benefits of it.
So you are on the edible side probably.
Lord, there was one matter years ago. Mr. Ghosh had briefed me in a matter to do with edible oils. It was sesame oil or something like that, some noxious kind of oil, and
Sesame oil is doing its rounds now. It's a fad now.
maybe
Not noxious.
Lord, the packets in which he had brought it, those poly packs,
Right.
Lord, he left it there and they left Lord marks all over the table. That's why I called it noxious. So anyway, I didn't want to, I told him to take it away. Years later, he still reminds me, তোর বাড়িতে রেখে গেছিলাম, হ্যাঁ তোর বাড়িতে এখনো তেলটা রয়েছে। কি হলো বাজারে এত মাল আছে দে আর কি আছে দেখি।
Yes, all look similar. Both look similar.
Now, Lord, please look at it. Lord, if it is there, these ought to also be stopped, if at all it's there. But no one has heard of these manufacturers. Now, where he has got it from, how, no bill disclosed, nothing to show it's selling in the market.
Our knowledge is limited regarding oil.
So is mine.
We don't know whether
So is
this.
mine.
We have never.
But the
I have
fact
never
is-
heard of this.
Name of manufacturers and
not-
marketing persons are all, because that is under the Legal
fact
Metrology
is-
Act. That has to be disclosed.
The fact is that no bill has been disclosed to show it is selling. That is all.
They know since 2023. They know the manufacturer.
I know
They-
the manufacturer. Oh, of
it
course.
has under the Legal
So
Metrology
then
Act.
you also must be knowing them. Huh? Achha. থাক, এখানে একটু থাক। So, Lord, this is the extent of it. Now, this is
You'll have to take all these back when you finish the matter.
Lord, they can be used to polish furniture and other things. Or, Lord, as we say popularly, Lord, tel dewa.
Literally, yes.
Now, Lord, this is the factual background of the matter. Now, given this, Lord, if I am correct in my submission and your lordships accept it, hey, adhik khali keno bolto? Adhik khali that. Now, Lord, if I am correct in my submission that this is only an action for passing off, or rather the orders in passing off, then we are then within a very limited scope, which is what? Lord, prior user will always succeed against the later user. End of the story. That's the normal rule in this space. It doesn't matter whether it's 1 year earlier or 2 years earlier.
Prior user is not denied here.
It's admitted because his date of user, even according to him, is 2017. 3rd March 2017 is his trademark application. I'll show that. Now, he has showed a total of about 20 or not 12 bills, but about a dozen bills to show sale of his products. I can show your lordship what is right with it, what is wrong with it, why it is inaccurate, but it's not necessary. I'll take it for a second that 2017 is a actual date of user. According to us, it's much later. But be that as may, taking 2017. Now, my lord, please compare that with the bills which we have disclosed. But please take, but starting from page 440, 404. That will be volume
Volume 3.
3.
এখানে আছে। Shall we be coming back to this can?
Not necessary. Not
You're
necessary.
keeping it in the region. Yes.
But I will rely on
Well,
in my reply.
It's there. 440.
Yes, 404. 404.
404, yes.
So, my lord, these are my bills. But starting from your lordship will find 2007. The date is right at the bottom.
Yes.
And if your lordship looks at it, so my lord, green label The first 5 are tins, first 4 are tins. So we also sell them in tins. The 5th and 6th are HDP.
HDP is this plastic.
Plastic. I think it stands for high density plastic something
Yes, yes.
or polymer.
Mr. Bhattacharya
Yes, he
said
was
on that.
trying to give us not what.
Yes, yes, yes.
But please turn the page 405, 406. All of them not contain this.
408 आरो आगे.
All right. But 408 is of 2006. So all these bills have been
Before
disclosed,
2017, much before.
and the genuineness of these bills are not challenged. I'll show that to your lordship from his pleading. There is only a bare denial. Just a bare denial, nothing more.
Green
And my lord, this goes on for the next lord.
এটা green ছিল yellow কয়েকটা দেখি.
So my lord, this is for the green. But similarly for yellow, your lordship will get from 409 onwards.
ঠিক আছে ঠিক আছে ঠিক আছে.
409 is the yellow HDP bottles.
These are wholesales. I mean, must be if it's by your company, has to be wholesale
probably
transactions.
Yes, probably to the distributor, possibly
To the distributor, might be.
distributor or maybe a retailer.
Because the company itself mostly sells it wholesale.
Yes, your lordship can see it from the
It's not an outlet from your works limited.
Yes, yes.
So this is sales.
Yes, yes. It's area sales office and all.
So
right. Very
so
good.
these bills
Whatever.
are there for the next 50, 60, 70, 80 pages.
432 টা হচ্ছে earliest 2006 এর.
And again, that yellow label, page 432, is possibly the earliest one in this lot. Again, going back to 2006.
ঠিক আছে.
So these bills are next, prior user by far. By far. But earlier than that, bills difficult to get hold of, I suppose. But out of curiosity, page 448. This is what the power of advertising is. But please see who. But I won't use the name. But well, coconut oil, pretty much, I would say, connected with this lady otherwise. And
Yes.
your lordship will see nowadays she does advertisements for drinking water filters.
Yes.
And fans. And I think what she displays most is possibly.
Both are equally, I mean, perennial, and
that's what. So,
that may be one of the reasons for you choosing this particular person. That it's an ongoing thing.
Of course,
maybe.
For a hair oil, they won't use somebody like Mr. Firoz Idulji.
Mr.
Firoz Idulji for a hair oil. Whom? Mr. Firoz Idulji.
No, but what always strikes me as very funny is,
yes,
hair will always remain black in color. Unlike this. But hair dyes have become so effective, one doesn't know who is.
Nowadays, young people dye their hair, I mean, in grey and other shades.
Your lordship.
It's the other way around now.
It is actually.
Black is not the fashion now.
Lord, I have a cousin. Well, she's just 1 year older than me, but her daughter was getting married about 5 or 6 years ago. And suddenly I find that from grey, salt and pepper hair, it's become fully white. Fully white. So I said, how did this happen?
During pandemic, many people had that.
The stress of marriage. I asked her, stress of marriage. So she said, no, this is the latest fashion. I've actually had it bleached till it's all silver.
No, people like, I mean, we need not take names, but say George Clooney or Milind Soman of our, country. So these people are nowadays, they're much more attractive than the younger generation. So all in paper.
But someone like Harrison Ford, who's now actually beginning to look a little old. But to me, I don't know. I still find him more handsome than or even Tom Cruise. I find them a lot more handsome than anyone else. So, this is so prior user cannot be disputed. It is not disputed, which is why my learned friend had to make out a case on infringement. So he runs a case He builds up an edifice for me, he demolishes the edifice as if not my case doesn't, not, it's not there. But the fact is, in passing off, not nothing really not in this matter. Number one, I am the prior user by far. Number two, he has not imitated one product of mine, but two, both conscious. He takes the color, he takes the get-up, he takes the labeling, he takes the not color scheme, and he takes the shape. In other words, the get-up. Now, in this context, please remember, Lord, my learned friend had tried to put it within trademark, and your lordship put a question to him. Are you saying that the get-up cannot be a trademark? And no answer, really proper answer was forthcoming. But the fact of the matter is, Milord, long before, Milord, the Trademark Act or the Trademark Act was amended or any new version, the fact is that get-up has always been, Milord, seen to be a part of one's mark. And I'll show your lordship the judgment. Before the Trademark Act was amended or anything.
Here I would like to, what is get up? I had shown Narayanan, specifically passage from Narayanan, what a get up means. It essentially means a device, not a shape of goods.
Yes.
That's
Correct.
what I had cited.
Correct. Now I'll show your lordship that, Milord, there have been judgments on shape of goods from time immemorial, long before, Milord, even this act came into force. The new act came in. I'll show your lordship that that same passage actually shows it. So, Milord, get up can mean anything. It is inclusive of the shape, the color, the individual devices, the name. It can be anything.
It's a holistic appearance. Actually,
Correct.
the appearance is the closest we can think of.
And that's how, Milord, every trademark
The impression that it gives. I mean, the
Absolutely.
appearance.
Absolutely. Which is why, Milord, the test has been your lordship size.
Yes.
Milord, in a trademark matter, at the end of the day, you can't say, look, these two bottles
No,
look
cannot be
different, but the labels are the same. You can't say that. You can't say the vice versa also. The container looks the same, but the label is different.
The
You can't.
test of a normal person has to be taken. I mean,
Correct, correct.
one
And
who
that
does not
too-
have the two side by side.
Correct.
Recall value and all.
Not a very searching examination.
Yes.
You're not looking out for the differences.
Right.
You are just, it's a general impression of an average everyday person.
Yes.
Not the test of a person with average intelligence and imperfect recollection. He's seen this product, he's seen that product. Would he say that they are connected? No, that's
Unless one specifically asks for that product.
there also. I'll show your lordship from the judgment he cites that, my lord, even that is not a test. Because in that matter, your lordship will see the evidence was the containers look the same. The labels are completely different. And if someone reads it, he will see that the names are completely different. That's what the judgment issue says. The court says, look, all that is ignored. You don't look at it like that. That's not the test. Because most people will not even bother reading the label.
The test of passing off cannot be on the standard or yardstick of a discerning person who wants a particular brand and sticks to that. That cannot be the test.
Correct.
Because then this entire story of passing off and infringement becomes irrelevant.
Not this common law, this entire
Right.
branch
If
of
it's a
thought.
brand of a cigarette, suppose you have that brand particularly, then there's no question of passing off. You want that brand and you check that brand only. Unless it's a
The target
provide-
consumers.
provide it.
The target consumers.
target consumers, yes. If it's a discerning product, here this oil is not so. I mean,
But,
the Veblen effect is not there.
But
It's
you-
not conspicuous consumption.
But even in cigarettes, I'll just take a different example. Your lordship is not thinking of a discerning consumer who will smoke only a 10 rupee cigarette.
Not
packet of-
cigarette, a particular brand of 10 rupees.
No, my lord, what happens is this. Not your
You
lordship.
don't go for buying, give me a 10 rupee cigarette. They ask for a particular brand.
Now, my lord, that's right. So for a 10 rupee cigarette, that would be correct. Give me a classic. Now, I'm sure, I don't know whether both your lordships have been smokers.
No, my lord is a pristine person. And I'm just the opposite.
Well, I hope
So
your
most of
lordship-
the vices which are available are there.
Well,
Probably.
I hope your
Barring
lordship
some,
was not
obviously.
pristine. Even
I would
in-
not have been of his other.
Lord, in college days and days before one was earning anything, Lord, in the profession. Lord, I hope your lordship was not pristine because
No, I
in
was,
those days,
never.
Lord,
I take advantage of my naive look.
Lord, if that be so, then please remember in those days, we would go to the, we won't buy full packets at all.
No,
One would
who
go
had the money?
2 টাকার cigarette there.
Yes, yes.
8 আনার cigarette.
We came down to Biris, Mr.
That's right.
At the end of the day, when we were, we had spent the money of our friends, then we went for.
So, my lord, if that is the
So you
situation,
never have
sir,
spoken
it was
of it.
never the
You couldn't have
design.
spoken.
You would not have looked at the brand name on it per se. It looks like
that is an extreme case.
It looks like a charm. Swell must be.
Charms was my first brand actually.
No, that's why I said.
But no, then I did no. Someone having no money, it's different. I mean, little money, then he'll make do with whatever he can. But a person who smokes a particular brand, suppose, I mean.
But that's a different thing. Your lordship has grown with
Yes,
time.
but that cannot be the test. That is what we are saying.
But your lordship has grown with time over 30 years. Your lordship has
brands have
developed
changed a lot.
brand preference. Now
If
your
you have a
lordship will
brand
only smoke
preference,
that.
yes, right? That's not a test for a passing off.
But a 20-year-old will not say, I will smoke only this.
Obvious.
I ask him for cigarette. He gives me
Right,
something else.
whatever. And you used to mark half the cigarette with pen. So you will smoke after this and I'll have the counter.
So
in the college days, yes.
So, this is how it was, and this is how it is for a normal, consumable product. We are not talking about items of luxury consumption.
True.
But Mr. Bhattacharya will not use a pen other than a particular brand.
Right.
And those are not made in India.
Obviously.
And not
how do you expect Mr. Bhattacharya to use Indian?
HON'BLE or something like that. Now,
he uses only Indian codes.
So, this is the long and short of it. These are normal consumer items sold in a grocer's shop, a pan-bidi shop, any other place. Now, Jif Lemon's case, which is cited, there, this same example was taken. That look, one is called Jif, the other was called juice lemon or lemon juice or something like that. So they said, look, just because the containers are same, doesn't mean that the people will be deceived because different names are written on the containers. That's exact argument which was made. I'll show that to your lordship. And there are 5 judges who have not held on it. Now, one of the interesting arguments in that was not what is being sold. Is it the container which is being sold? Now, Lord, give me the bottle. Lord, I am not a seller of containers. If I was a seller of containers, the test would be, is this a registered design? Am I the only one entitled to sell these containers for selling oil? This is not a case where I'm selling containers. I'm selling oil. I'm selling oil within a particular packaging and get-up. If I was selling containers, the test would be different. Then this argument about not having a monopoly on the design, on the shape of the bottle, all of that may have been relevant.
Unless the identification between the container and the product is unique. Like in that, the shape of a coconut. If it was the shape of a coconut.
Correct. So, this is the test. I'm not selling plastic containers. I'm not a manufacturer of plastic bottles. I am selling oil with a particular get-up. So, this is what 5 of the lords of the House of Lords said. And that's why the conclusion over there. The names were different. The packaging was the same and both were selling lemon juice. So, they held, look, you are selling lemon juice. That lemon juice has become identified with this shape now with the plaintiff. So this is how it was dealt with. I'll show that to your lordship. So, to go back to the test, therefore, I've summarized it, but number 1, I am the prize user. Number 2, he comes second. Now, if he comes second, he has to explain how he has sailed so close to my packaging, design, get-up, shape, color scheme, all of that. No explanation forthcoming other than hearing, look, the whole world is using it. Now, if the whole world is using it and you have no monopoly, if that be the argument, then my learned friend proudly shows you that he has applied for registration of this shape, claiming the shape. Now, if it is not there for the whole world to use, how did he claim it? Give me the page number.
744, 745.
Please take page 744, 745.
That's volume.
He can't have double standards.
4.
so much not noise about, look, there's a way in which you get the shape. You have to apply in this form, that form, claim this, that, and the other. So now, my lord, if it is common to the trade, the whole world is free to use it. How has he applied for the color and the shape? Please come to page 744. 744. Yes. Page 744. Now go 7 or 8 plot rows down. Trademark type, shape of goods. And surprised by him. We disclose this. Now, from here, your lordship will also get his date of user. User detail, 3rd March 2017. So he's stuck with his 17 user. He can't say I've been using it from 1905 or whatever. 2017, later user, and he's claiming the shape. So, my lord, there is a line of judgments which I'll again show your lordship. If you claim registration of this, you can never take the defense of common to trade.
But there is no shape unique to either your product or their product.
Yes,
because you are selling in all sorts of containers, all shapes, materials.
No. I'll come to that.
So how can you say that?
Yes, now I'll come to that. Just give me the bottle.
Going by the bottles you were showing also, and there are tins also.
These are different sizes. The shape is the same, not irrespective of my color and the size. Please see. Not, I'll just hand it up.
Yes.
I am maintaining uniformity across my, not the small one. Uniformity. That is the same.
That also has the ribs.
Yes.
All right. You need not give it. Yes.
They are all identical. So I'm not using multiple designs. I'm using 2 colors and the same design across.
Yes.
Across.
But you are from 2017.
Now, my learned friend made a lot of this. Now, Lord, please see. Lord, this is what I call dishonesty. Please see what this is. Have a look.
Hair oil.
See what hair oil? Please see. Enriched.
Enriched, yes.
Enriched. This is not pure coconut oil. These are pure coconut oil. These are flavored. Please have a look.
Enriched coconut hair oil is written there.
Please see these are flavored.
Enriched or impoverished, whatever.
Wrong.
It's coconut
wrong
hair. Coconut.
No, these are flavored, not flavored, or scented. Scented. Jasmine. Please have a look. These are the scented oil. Jasmine. This is not edible. Not your lordship, see the picture of jasmine. Not a lot of people use scented hair oil.
Maybe. No idea, Mr.
So, Lord, this is not edible.
We are absolutely neutral on this.
No, your lordship will find on that.
Literally.
আরে দাঁড়াও না, ওখানে জ্যাসমিনটা কোথায় লেখাটা ওটা দেখাও না, হেয়ার অয়েল পড়ে যাচ্ছে। এখানে ছবিটা আছে। So, these are all flavored oils. Please see the picture of jasmine here.
No, we are saying that
obviously not flavored because one can't eat this. So, these are the scented oils. So, this is a different product altogether. That is why it has.
But you are picking and choosing. I mean, both of you. I mean, you also have an array of products of all sorts of coconut oils, and they also do have that.
I'll show you a lot cheap array of products.
Because you have yellow, green,
I'll just show you.
Bottle shape. Yes, I understand. Unique from 2007. You are the prior user. We can understand that. And there may be an identification with the bottle also.
Difference is blood. Your lordship will find these are not. But this is pure coconut oil, which is edible. Those are not edible. Those are scented oil.
That how does a customer know by looking at that?
Yes, it's there. The picture.
Unless one has it and then falls sick or otherwise.
So now, please take page 130.
Yes, obviously the bottle Mr. Bachawat was showing also was.
Please
These
take
are their products.
Please
It's not
take
just one.
Yes, please take page 136.
130 of what?
এটা কোনটা তোমরা এই কোথা থেকে দিলে এটা? হ্যাঁ বলুন, দেখো না পেজ 136 একবার
দেখলে গায়ে জ্বর আসবে।
একবার দাও।
কোকোনাট অয়েল দেখলে গায়ে জ্বর আসবে।
ঠিক আছে, ওই ছবিটাই দাও না, ওটাই দেখিয়ে দিচ্ছি, জয়জীব দিয়ে দিচ্ছি। You just save some time. ওই পাতাটাই দাও না। হ্যাঁ, পেজ নম্বরটা বলো।
716.
716.
We can see those are their products.
716. That was 716.
You have all sorts of bottles, blue, green, yellow.
No.
They're all yours. We can
Yes.
see from here.
Yes, please take 716. It's there in the paper book, 716. I know, thanks.
Yes.
So, my lord, within the coconut oil, these two bottles, ota there is scented jasmine, and yes, and this is the other one.
So there are so many types of bottles, Mr. Bachar. How can you say the
Only-
customer will identify with one of your?
There are 3 bottles only. As far as the HDP bottles.
No,
are
the last one, the right hand side,
Yes.
Kalimar, that's of a
That's
bit
the
different.
blue
That's
bottle.
smooth. Yes, this.
This one.
This is smooth, not ribbed.
Yes.
And the
Even
cap
the
is
blue-
also a bit
Yes,
different.
this is not a scented hair.
Blue.
This is scented hair.
We have seen blue also.
This is scented hair oil. This is scented hair oil. So this is not coconut oil.
No, the blue one, my
Your
lord.
case of passing off is generally regarding coconut oil, your coconut oil products.
No,
My lord,
he's got other. He's also got not these.
That you cannot keep it fluid. That I
We'll
mean,
kindly see
whatever
this one.
products I make there.
Would
passing
your
off.
lordship
See
take-
this one.
would your lordship take can 1? Can
Sir,
1?
we have
can-
seen all.
Would your lordship take can 3 once? Lord, the opposition which I showed your lordship.
Yes, can see
একবার দাও না, ওটা বার করো।
opposition.
দাও, ওর product line টা একবার দাও। So, my lord, he's also got scented hair oils. The scented hair oil has to be in a different packaging. Please take, my lord, page 17 or 16. So, my lord, he's got scented hair oils. Those come in different packaging, naturally.
You're not complaining.
I am not complaining about the scented hair oil. I am complaining about the get-up of the bottles of pure coconut oil.
Which are
Sorry,
page.
I have not tried to stop any of his other products, page 16 and 17.
16 and 18.
Not each of his scented hair oils. Each of his scented hair oils, my lord, if your lordship sees, there is thanda tel, there is, my lord,
Yes.
jasmine oil. I'm not complaining about those. He's got jasmine oil also.
Right.
If your lordship sees page 18, he's got a variety of oils.
Yes. Yes.
I'm not complaining about that. I'm only complaining about this.
Page 17, you are complaining.
But in each of them, your lordship will find, my lord, page 16, 17, 18.
Yes, 16 also.
17, your lordship has got that green bottle
Yes.
Green and yellow.
and the yellow on the right side. These two are the ones I'm complaining about. The one in the middle, that KMP coconut oil that he's got, that is a copy of
Parachute.
The other
Parachute.
one.
That's a copy of Parachute.
No, you also have similar thing.
I'm not complaining about that. I have not
716, the second bottle.
I have not complained about it. I have not got an injunction on it.
What is your pleading on that?
Pleading
That-
on this.
What are you complaining? I mean, you have specified
But
green and yellow.
Yes. Let's go to the prayer.
Green and yellow.
Well, please come to our prayer. I'll show you a lot.
Yes, we just look at that.
But I'm not against that blue. My learned friend has said across the board, I'm claiming violet, indigo, blue, green, yellow, orange.
Yes.
I have not.
Yes,
I've claimed these two and these two alone.
That was the impression we were also having. In fact, we should have looked.
My
into
learned
it.
friend says a lot of things, but not.
No,
Is
not
that his
because of
case?
him also.
No. Is that the case?
Let us see
But
your
let's see the prayer.
Same
Please come back to the prayer, my lord.
Same case.
page 87.
But I've got lost in the volumes. Just give me 1 minute. To
Yes,
put it
yes.
Volume 1.
up. আমার volume 1 টা কোথায় গেল?
Para 36.
ও এখানে রয়েছে।
No, you claim on the.
But my complaint is only on these two bottles of his. And if your lordship comes to the
42
prayer,
is the prayers of the petition.
if your lordship comes to page 42,
142.
oh sorry, I'm sorry.
88 is 87.
That's the plaint.
Yes.
Your
Yes.
lordship takes page 142, that's the
Yes,
prayers
please.
of the petition.
Please take the price of the plate. Because it's with reference to the pictures, page 87.
No, plaint and injunction are the same prayers. Same.
Yes, same. Not with reference to the label itself. So I don't see what the problem is. And Lord, this is with reference to, Lord, please come back to the comparison. I don't know whether your lordship has colored ones there.
No.
But at page 119, if your lordship sees, this is what the complaint is. Page 119.
No, these are black and white.
Lord, I'll just give the colored one. This is what the complaint is.
এটা difficult হবে, you color
Lord, I have 2 copies. এটা একটু দিয়ে দিন না,
take this.
Please turn the pages.
Color
I am not claiming anything
So,
else.
my learned brother has a colored copy. So
Oh, I see. Lord, I am not claiming, Lord, a injunction on Lord Imami's hair oil or anything else. I am saying you are copying my green and my yellow bottles.
you are claiming on all these products. There are several.
No, only 2.
Page 20, page 19 also.
Page 20 and 19.
20 is what you showed to us.
Yes.
Page 19.
Correct. It's the same product.
And page 21 also, the letters.
Same. But this is the label. Not that's not what is not this part. Please see this, not if I may, this part.
All right.
Your lordship sees with reference to color, it's only these 2.
You have claimed for restraint order, passing of its goods under the impugned trademark trade dress
Yes.
by manufacturing, offering for sale, and given those.
Green and yellow.
So those are tins. The part of B, prayer B.
No, Lord, that's not the tins. That's the
label.
Lord, that's this part. These labels, Lord. It's
That's a part of the bottle.
Yes.
All right.
It's part of the bottle.
Right. Get it.
But I have nowhere tried to say stop him from using the blue one where he's copying Lord parachute.
That helps you because they counteract against each other. So very well. So you are restricted to these 2.
Yes.
And you have not given the copy of the any photograph of the entire bottle anywhere.
Yes. We have.
You have also given that. In the prayer portion, you have not.
In the prayer portion, yes, also there. Also there.
Not in B.
Not in B. No, not in B. But so lordship takes page 119. Lord.
Yes, 119.
This is what the complaint is. The whole bottle is there. The 2 colors. With specifically saying over there, striped lines, yellow and brown, red, as well as blue and green. His is also that. Label, we've described the label in Lord with details. What is copied, what my complaint is.
All right. So, very well.
Lord, to get back to the point, Lord, the point here is very simply this. Lord, I am not stopping him from manufacturing coconut oil, whether edible, non-edible, scented. He is free to manufacture. But do not use my bottle and packaging and get up. That's all that there is to it. And that's what the law of passing off is about. Now, here the simple test not to apply is, but the test of passing off is a one-line test.
Yes.
Would anyone not using or seeing his product even not remotely think that it's connected to mine? That's all that there is to it. Now, there is no difference between the 2 at all from a distance for sure. Now, if your lordship then compares, Lord, I'll just give you a lordship for the side-by-side comparison.
Can you place that their yellow and your,
yes,
the others?
Yes. It would change and it agita go. But if your lordship takes it and does a Not close.
One yellow and green of theirs and one yellow and green of yours.
If they want, this is a closer shape.
Those are both yellow. We want one green and yellow.
Yes.
এত দরকার নেই
একটা দে না তোদের।
ওদের একটা হলুদ একটা সবুজ আর এদেরও একটা হলুদ একটা সবুজ
চলে গেল।
Your juniors will help. Yes. One green and yellow of yours and one green and yellow of
This
theirs.
green is missing. My green is here. No, blood. There was one green which has apparently
gone under the table.
Gone under the table.
This is another yellow.
না এটা দুটো
তো দিয়েছো
এটা দুটো আলাদা জিনিস দুটো
আচ্ছা closer side
আলাদা কালার মিলিয়ে লাভ হবে না একই কালার লাগবে This is KMP yellow, Shalimar green. We want either a
Yellow.
আচ্ছা
And KMP green টা ছিল তো।
পড়ে গেছে বাবা বারবার ওটা বলে কি লাভ
এই দুটো একটু দূরে ধরে দাঁড়ান তো ঠিক ওরম ভাবে না সোজা করে হ্যাঁ ঠিক আছে দেখে নিচ্ছি ফেলে দিন না ওর ডিসকাশনে যাবেন না
একবার আমায় দিন
তারপর ফাইলের মতো হয়ে
I'll never be asked to model anything in my life. So let me take this opportunity and
you look good, but the bottles
it's the other way around.
Yes, we get it.
People spend a lot of money on packaging, shapes, setups.
Yes, they do.
Lord, there was a time, I don't know whether your lordship remembers, but it was mind-boggling to us 15-20 years ago. Google changed the way in which their G was written, remodeled it. Yes. And that was a 1 billion exercise, $1 billion exercise, this rebranding.
Achha.
So, these are well thought out.
Yes, we get them.
Now, this is the long and short of it. I don't think there was too much to it. Now, to get to the law. First, I've showed your lordship 27(2) of the Trademark Act, common law, left untouched by the Trademark Act. Now, yes. I'll give your lordship one judgment on it. Now, what these judgments say, there's a line of judgment saying it, but what they say is, number one, the statute only recognizes a pre-existing common law right. Nothing more, nothing less. If there is no right, the statute can't recognize it, etc. Getting that statutory recognition without having a common law right means that statutory recognition will be inferior to the common law right. So your lordship will have judgments going back right into the 1980s, where a unregistered proprietor of a trademark, a common law right, has got an injunction against someone who has a registered trademark. So that's why it is said that the common law right is superior to the statutory rights. And I'll give your lordship one judgment on that, not for the time being. And that also says, yes, I'm
not disputing that. You have learned this law in his chamber. I'm not even disputing this for a moment.
No, this is just to say this, that two tests, and they're actually well summarized here. So your lordship could have a look at. But I won't read all of it. But if your lordship marks off, from para 28, or I'll place it, Moinuddin. But para 28, if your lordship comes to. The law of trademarks in our country is perhaps not as far as Supreme Court judgments go. It starts off from 1960 itself. Oh. And your lordship will find that our law of trademarks is probably one step ahead always of other countries, strangely. And I'll give your lordship one example. This thing that he was arguing, different product, different class of goods, different categories of goods. Now, this theory surprisingly was exploded in our country by the Supreme Court in the 1960s itself. It said it doesn't matter whether the category of goods is the same or dissimilar. So, Supreme Court said that. And that is also the subject matter of a larger bench decision of the Calcutta High Court, because there was a little problem in the Calcutta High Court. There was a division bench judgment reigning for years, which there was Bata shoes and Bata mattress. And one of our division benches in the early 50s or 60s Lord had said that they are different class of goods, so no injunction can be granted. So because of that, Calcutta High Court was held back.
The Bata
from
shoes and Bata mattress.
Mattress. Two different companies.
Yes.
Bata.
Two different products.
So two different
products.
Yes.
Completely
So
different.
Lord Bata could not get an injunction against the mattress. So Lord, the other judgments across the Supreme Court and in other countries said that it didn't matter if the products are different. You can get an injunction. Now, this came in the way in the Calcutta High Court for many, many years. And then, my lord, one of our division benches referred that matter for a decision by a larger bench, and the larger bench decision of a bench comprising of Justice Aniruddha Bose, who was not again, let's put it this way, not very specialized in this or had specialized knowledge in this area, said that no, it will not matter whether the goods are the same or different, passing of action will always lie.
Provided it's a well recognized.
But a shoe of your company can be passed off as a mattress of the other company.
No, my lord, provided it's
No,
a well
not-
recognized.
it's not the product.
The mark there was Sony. Where Sony is such well known that people might associate Sony with.
You distinguish
Western.
it after I've shown the judgment. I haven't shown it yet.
Understood. Understood.
But the point here is something else. Not passing off. But what is it to do with?
No, we have understood. My bad, I could not answer.
For example,
If the name is same, I mean, yes,
yeah.
understood.
Not for example.
Even if the products are different.
But it sometimes borders to the line of ridiculous, but I found it ridiculous. But Mercedes, the car manufacturer, filed a suit against a Genji manufacturer who was making Mercedes brand Genji.
May. I mean, because it may happen.
And they got an injunction.
Because nowadays, Mr. Bachwat, all the more so because every good brand is diversifying its.
Correct.
Suppose Red Bull is in F1 racing.
Correct.
What does Red Bull, the drink, has to do with the F1 racing? And accessories?
No, that Red Bull is the sponsor of that F1 race.
Sponsor?
It's that same company. It's the same company.
Same company. No,
Yes.
we are saying that, I mean, but therefore they are diversifying.
Correct.
So if somebody does something entirely different from the main product, it may be affected. I mean, one thing.
Mercedes,
not just that.
They have come up with perfumes also.
Chains, perfumes, everything.
keychains,
Yes.
everything.
But this
And not only
merchandising.
that, they said yes.
Caps. Everyone will have
Caps,
their caps.
everything. Not only caps are also related to racing, maybe, but things like earbuds. They have.
But to give you a
Yes.
story, just digressing. I've never been to a client's house or something for a. So this gentleman who used to live 3-4 houses away from mine. He had a fleet of Ferraris. So I got myself invited. I said I want to see your Ferrari lounge. But that lounge was made entirely of Ferrari stuff. From clock,
all accessories and all.
Clock to furnitures to everything. Ashtrays to everything was a Ferrari.
If I had clients like those, I wouldn't have taken up this.
No, he came pro bono through another client of Mr. Bachawat only.
I know. But if one looks at the history of how clients come and what happens, sometimes.
Yes. Absolutely agree.
But I have some hilarious stories about my senior. So, what I shall say? It's a real. I had just joined the profession, brand new. I was 2 or 3 months in, and court was lying shut because there was a strike going on. So, a friend of my senior, he came in and he'd been asking.
Your
for
senior was Mr. Pratap Chatterjee.
Jointo Mitra.
Oh, sorry.
So, he had been waiting for a plane to be settled for 6, 7, 8 months. And he was a friend and he would make some excuse and send him off. So that day when he came in, I was there, he called me in and he told him, look, this young man, he knows everything about this kind of matter. Very bright fellow. He's come from England. He knows this area of law inside out. I knew nothing. Now, what was his case? The man wanted his name put in the Guinness Book of World Records. He said,
suit was going to be filed for that.
Yes, he wanted that done. He was done. No, my lord. So he came. So I did my best. I then made up a case of unilateral.
Drew up a plaint on that. I mean,
yes. Not it was based on law. A lot of law. A lot of work went into it. It is like this. Your lordship knows Carlyle versus Smokeball, a company, a carbolic smokeball, unilateral offer. If I make an offer to the whole world and I take it on by performing, then it's a completed contract. That and there were other things, whatever. So I wrote it out. And then my senior was taking time to settle it. So one day this guy comes and he says that, look, they are about to release the new edition. So we have to move. We have to move by day after or something like that. So I went to him. I was very scared, 3 years in the profession, very scared to even talk to him. So I told him, he said, acha, tu thik kore likhecho? So I said, and it was the first plaint I was probably drafting in my life. So he added, he added 1.5 or 2 more pages, and we moved, and we got an order of injunction. Then we got they were selling in violation of that order. So receiver was appointed to pick up all Guinness books of records wherever they are in the country. So anyway, now that's not the part I wanted to narrate. So order passed, we come out of this courtroom, not this very courtroom. And the client is very happy. So the first man standing there was my senior's bearer. So he takes out and gives him 10,000 rupees.
10,000 rupees?
10,000. Then came someone else, some chaprasi, this, that, everyone is getting now reduced amount till it comes down to my senior's clerk. And I burst out laughing, seeing that he was given 100 rupee note. So that's how it happened. So
one judge's orderly got caught in Gujarat or somewhere having a scan code for GPay.
Yes. One read
That's
about
very novel. I mean, I always look out for my orderly. If there is even something remote like that, I mean.
So this gentleman was not very loving kind of person. And I could never ask him for, I would never ask him for fees. He would just come in, open
the
my
lawyers
door.
were next in line after those payments.
No. We never asked for any fees because he passed.
He was our client senior, and he was a senior's friend, and we never asked him. But he would come in and insist. He would just open the door and put an envelope.
Got passed on to Mr. Bachawat, and from him.
Oh, you also great.
And your lordship will not believe it, but Guinness Book ultimately appealed this, that, did everything, and they ultimately settled the suit, and they agreed to set up a circumnavigation trophy called the Salu Chaudhary Circumnavigation Trophy for driving around the world, and to set up a prize amount.
That was a pioneering sort of suit then.
So that was fun.
We have a bench.
Oh, I see. I'm sorry, my lord. I digressed.
No.
We have made some headway.
So we'll start from this judgment.
Only one thing I'll point out.
Yeah.
But next week, I believe after 19th, my learned friend is not
19th, second.
Not there.
I'm
He's not there for 10, 12 days.
Monday,
If he's not there for 10, 12 days. Now, it's pointless not placing it in a way in which I finish my submission and he replies after 2 weeks. That's all I was saying.
if it could.
Appearing the list, if you're in difficulty,
Tuesday onwards is Tuesday, second time onwards.
For 11 or 12
ask somebody to ask for time. Mr. Bachawat won't be opposing our purpose. Heard in part for further hearing on August 18, 2025.